Ladies and gentlemen, I want to welcome you to It's Rainmaking Time. I'm Kim Greenhouse, and we have a really special show for you today. I want you to imagine that you are being brought back into the time of the founding documents of the U.S. Constitution. I want you to imagine that you're there with the founders. The United States of America is going through something that was thought about deeply by the founders. And this document, while people may not think it's a living document because it's from the past and they want to change it to update it for today, keep in mind, you haven't met our guest yet. And for those of you that have, you know how special it is. So, one of the things we're going to talk about today is we're going to talk about presidential power and authority relative to state power and authority, and what happens if the cooperation of states with the president doesn't happen. We go into what-if scenarios. We talk about the Federal Reserve. We talk about scenarios about what is constitutional and what isn't. And for those of you who really wanted to get briefed, we have one of the greatest masters in this area in the United States. So buckle up, bring your pen and paper in case you want to take notes. This is in audio. It's being shown on its rainmakingtime.ch. It'll be up also on YouTube if YouTube allows it. We're censored for whatever reason. About 50 segments were removed from YouTube, so we post as we can. But everything can be found on Apple Podcasts and other distribution networks for audio. But for audio and video, if there's a video involved, it's on its rainmakingtime.ch. Everybody enjoy the show. This is produced and brought to you by the Rainmaking Company at rainmaking.ch. Thank you so much. Dr. Edwin Vieira is a constitutional scholar, a mastermind. He has fought cases in the United States Supreme Court, Abood versus Detroit Board of Education, Chicago Teachers Union versus Hudson, Communications Workers of America versus Beck. He has a depth and a breadth of understanding the Constitution and teaching it to others just by hearing him speak and share what the Constitution actually says versus how we, the public, are interpreting things, particularly the public that hasn't read it. He is the author of so many books. I'm going to name a few. Constitutional Homeland Security, A Nation in Arms, How to Dethrone the Judiciary, 3 Rights, 13 Words, Pieces of 8, The Monetary Powers and Disabilities of the United States Constitution, The Sword and Sovereignty, The Constitutional Principles of the Militia of the Several States. He also has a DVD lecture called The Purse and the Sword, and other publications. Before I bring him in, I want you all to know that we did a piece in 2020 called Calling in the Constitution, which is a 2-hour special that you should all see, and many other interviews. But that one in particular, I'd like to invite you all. We've had him on several times in the last several years to cover different things, events, and concerns that are going on in the United States. I've invited him back because there is so much concern, even by journalists and very popular show hosts and podcast hosts, worries about our president going into different states and bringing in the National Guard and expressing concern that this is a kind of militarization that's unconstitutional. And many people have this concern and other people don't. So we want to really clarify this. We have many other things to talk about, but this is very important because it's happening right now. Ladies and gentlemen, welcome Dr. Edwin Vieira back to It's Rainmaking Time. Thanks so much for being here.
Well, thank you very much for having me, Kim.
I would like to talk a little bit about, let's take Chicago as an example, since it's a hot topic. It happens to be on people's minds. The governor does not want the National Guard and many people in Chicago entering the state of Illinois. And a lot of people are saying this is illegal, it's unconstitutional, the National Guard shouldn't be federalized, they have no jurisdiction. And even though you and I did a piece about constitutional authority, I think we really need to drill down into this way more.
Well, the predicate for this, or the scenario, is that President Trump is going to, quote-unquote, federalize the National Guard, take control of the National Guard, and send those people into Chicago in Illinois. I think other cities as well he's considering doing. And the question is, well, what is his authority for doing so? And that depends upon also what is the National Guard, because many people confuse that institution. If you look constitutionally, the president is authorized, he has the status of Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. That's an exact quote. And then Congress has the authority to provide for calling forth the militia to execute the laws of the Union, that is, on the national scale. So if we look at that right away, we can see that the militia is something that is subject to congressional call and presidential command. If we go to a lower level, we see that in every one of the 50 states, as far as I know, the governor of the state is made the commander-in-chief of the state militia, because the Constitution talks about the militia of the several states. There are 50 of them. There were 13 when the Constitution began, and as the states expanded, each one is supposed to have constitutionally a militia subject to the president as commander-in-chief. So the question is, what does that militia comprise? What does it constitute? And typically, in each state, the militia is broken up into two components, one called the organized militia and one called the unorganized militia, sometimes the reserve militia. The organized militia is synonymous with the National Guard. And if you look at most of these statutes, that's what they say explicitly. Congress has also said this because it has defined the militia of the United States as composed of two classes: the organized militia, which consists of the National Guard, and the unorganized militia, which consists of everyone from 17 to 45 years of age who is not a member of the National Guard, excluding women, because women can be members of the National Guard. So Congress has set that statutory age bracket. In Virginia, for instance, the state statute brings in people from 16 to 55. And so those age limitations are different in different states. But at the congressional level, the level at which Congress can call people forth, anyone from 17 to 45, unorganized militia, and then everyone who is in the organized militia National Guard. Those people potentially are subject to the control of the president if there is some statutory authority under which he can call forth the militia in the actual service of the United States, to quote the Constitution. Now, there are such statutes, and so we have to consider those in terms of what power, what authority do they give to the president. And then secondarily, there's always a consideration, well, what about the prudence of exercising that authority? It's not always necessary that because the president has some authority, he ought to use it in certain circumstances. And then thirdly, there's the practicality. What are the difficulties or problems that may arise in using these forces? Now, what's happening in Chicago in particular is that the governor of Illinois and the mayor of Chicago are expressing their dissent from the existence of certain powers of the president, or their claim to have their own authority to interfere with this. Now, all I can say about that, under the laws of Illinois, as I happen to look these up, Constitution of Illinois, Article 12, Section 4, the governor, they're talking now about Mr. Pritzker, the governor is commander-in-chief of the organized militia, that's the National Guard in Illinois, except when they are in the service of the United States. the actual service of the United States is being referred to here, that constitutional provision that I quoted earlier. When they are in the service of the United States, who commands them? The President of the United States. So, under the Constitution of Illinois, Governor Pritzker, although he is nominally the commander-in-chief of the militia, he becomes subordinate to the president when the militia of Illinois are called into the service of the United States, right there in the Constitution of Illinois. All right. Then secondly, in the Constitution of Illinois, the statutes of Illinois, it provides that whenever all or a portion of the Illinois National Guard is called or ordered into the actual military service of the United States by the President of the United States or the Congress of the United States, it shall be the duty of the governor as commander-in-chief to furnish such troops.
Can we get into the detail about this? Or
Well, I'm going to right now.
This is very good. Okay.
All right, so this statute makes it very clear that when the president calls forth the organized militia of Illinois, the National Guard, not only does the governor lose his position as titular National Guard commander-in-chief, become subordinate to the president, but it is his duty at that point to provide for, to furnish such members of the National Guard as have been called for. So he really has no separate authority by which he can, in some sense, refuse to comply with an order of the president, provided that the order of the president is constitutional. Well, we read the constitutional provision, and it on the basis of some statutory provision, because it's Congress that provides for calling forth the militia to execute the laws. So you have to have a statute there. The president can't take it upon himself to do that. So there are many statutes that are potentially applicable here. What's interesting to me is that the people from the White House, staffers apparently, have chosen one which I think doesn't really apply. It's Title 10 of the United States Code, Section 12406. And it says, whenever the United States or any commonwealth or possession thereof is invaded or is in danger of invasion by a foreign nation, or there is a rebellion or danger of rebellion against the authority of the government of the United States, or the president is unable with the regular forces to execute the laws of the United States, the president may call into federal service members and units of the National Guard of any state in such numbers as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws, and orders for these purposes shall be issued through the governors of the states. All right? So in those circumstances, that language, orders for these purposes shall be issued, that goes back to this duty concept. It's a requirement. When the president decides to do this under this particular statute, and he gives orders to that effect, the governors of the states must take those orders and enforce them.
Then why is it, for example, that some governors, I think even Newsom, are saying that the president is overstepping his presidential authority by thinking he can go into the states and put the National Guard in there? Where is that coming from? A lack of constitutional knowledge? Where are they getting it from? They've got to be talking to attorneys.
Well, I just read give the example. I don't have the California law here, but it probably says the same thing as the Illinois law. The governor has a duty when the National Guard has been, quote unquote, federalized, has come under the authority of the president. And here's a federal statute that says the same thing. Orders for those purposes shall be issued through the governors. Well, that means the governors are required. Again, they have the duty. They shall do it. They don't have the choice that they will decide to do it or not to do it.
So what if they don't do it?
Well, let's get into that.
Okay.
All right? We'll get into that, okay? Because I want to go to the statute that actually I think applies here. A better statute, let me put it that way. And that's Title 10, same title of the United States Code, Section 253. And I don't know why the people in the administration haven't considered this one. And it says, the president, by using the militia or the armed forces, or both, or by any other means, shall take such measures as he considers necessary to suppress in a state any insurrection, domestic violence, unlawful combination, or conspiracy, if it so hinders the execution of the laws of that state and of the United States within the state, that any part or class of its people is deprived of a right, privilege, immunity, or protection named in the Constitution and secured by law, and the constituted authorities of that state are unable, fail, or refuse to protect that right, privilege, or immunity, or to give that protection, or opposes or obstructs the execution of the laws of the United States, or impedes the course of justice under those laws. Now, that language at the end of this provision, and the constituted authorities of that state are unable, fail, or refuse to protect that right, privilege, or immunity, or to give that protection, is what the Trump administration is saying is going on in Chicago, in Baltimore, and some of these other large cities. You have domestic violence, you have unlawful combinations, gang activity, conspiracies.
What does that mean, conspiracies? What does that mean in action?
It's two or more persons acting in concert for an illegal end through legal means, or for a legal end through illegal means, or for an illegal end through illegal means. As legality, two people, they're getting together and they're engaging in some sort of illegal activity as means or ends, right? Well, every criminal group is engaged in conspiracy. Right? Think of the cartels, drug trafficking, human trafficking, on and on. You have two or more people engaged in criminal activity, you're dealing with a conspiracy. It's also an unlawful combination. It also involves, in many instances, domestic violence, right? Robbery, carjacking, drive-by shooting, on and on you go. So this statute clearly covers all of those instances that one can imagine in inner-city Chicago that are going on in what's called the breakdown of law and order. But the important part of this statute is the constituted authorities of that state are unable, fail, or refuse to protect the right, privilege, or immunity, or to give protection to the citizens. And that's, I think, the Trump administration's point. That if you look at the authorities there in Chicago, the municipal authorities, if you look at the state authority, that would be Governor Pritzker and the state police, others that he can mobilize, or the National Guard potentially, they're failing to do what they need to do in order to provide a proper level of protection to their own citizenry. Under those circumstances, the president can step in and he can use the militia or the armed forces or both or any other means to take such measures as he considers necessary.
Well, how many governors, for example, can we cite who have said, or mayors, there's nothing wrong here, there's nothing abnormal going on here, he's making a big deal out of nothing?
Well, the statute points out that he shall take such measures as he considers necessary. So who is the judge of the severity of the situation under that statute?
And what happens if Pritzker goes to court about this? What happens?
Well, I think if Pritzker goes to court with it, and there are judges who are, how shall I put it, apprised by the Trump administration, because obviously Pritzker isn't going to read this statute to them, apprised by the Trump administration of this statute, constitutional provisions, the court will throw Pritzker, out. His suit, whatever it is, probably for an injunction, will be dismissed. And then what will he do? Well, he'll appeal, and that will be denied, and then maybe he'll take a petition for surety to the Supreme Court, heaven knows. Right? He can go through all of that process. However, I would simply say, well, that process is going on.
The president doesn't have to wait.
I don't think he does.
Well, how would we know?
Well, because let's go back to 1827. We're talking about judicial precedents here. There's a case, I would say it's a famous case. The people that pay attention to Supreme Court cases, but I imagine quite a few people don't know about it. It's called Martin versus Mott. And this was a case under a predecessor of one of these insurrection, domestic violence statutes. I think it was written in the 1790s, that particular statute. And it provided for the president to call forth the militia when he considered that certain situations were necessary, create a situation that was necessary for calling forth the militia. And a member of the militia dissented from this. He said, I'm not going to show up because I don't believe the situation is sufficient under the statute for the president to exercise his authority. So he was essentially second-guessing the president. And he was court-martialed. And eventually the case wound its way up to the Supreme Court of the United States. And that was the question. Who under such a statute where the president is given the authority to determine what is necessary for calling out the militia? Who is the final arbiter of what is necessary? Is it the president? Is it some member of the militia? Is it the court system? Who is it? And the Supreme Court said, well, it's certainly not the member of the militia, and it's not us, the justices. It's the president. Congress has given the president, under Congress's authority to provide for calling forth the militia to execute the laws of the Union, has given the president this authority to decide when the exercise of that power is necessary. And under those circumstances, when Congress has given such a power to the president, no one else can second-guess him, including us.
What about the order coming through that the militia, a.k.a. the National Guard in this case, let's take the scenario a little further. Is the National Guard called upon by the president, and the National Guard comes from an area outside of Illinois or inside Illinois? In other words, is the National Guard in Illinois the one that's answering to the president? Like, where are they taking their orders from in this scenario? I'm confused.
Well, it makes no differentiation in this statute. The president, by using the militia or the armed forces or both or by any other means, well, the militia is this broad concept. It's the National Guard, the organized militia is the National Guard. Well, there's National Guard in all 50 states.
Who's giving the orders, I guess, is my question on the ground.
Well, it starts with the president.
The ground.
The president decides this is necessary.
Right.
He passes it on, I would think, as a matter of comedy. Not comedy. We're going to do something in recognition of the governor's position there. He passes it on to the governor and says, this is the order I want you to execute. I want you to bring 5,000 National Guard, whatever it is, into the city of Chicago, and here's the protocols they're going to follow in dealing with the Chicago police and the local authorities, and this is what you're required to do. And then theoretically, if the governor were following the law scrupulously, he'd do it. We don't know what Governor Pritzker would do if he gets this kind of an order. He talks a big game, but we don't know exactly what he'd do. We certainly don't know what the mayor of Chicago would do, because the mayor of Chicago has no authority whatsoever over the National Guard. He's not some subordinate of Pritzker's within the National Guard chain of command. He's the mayor of Chicago. Pritzker is the only one in Illinois, that has this direct National Guard authority. But his authority is subsidiary to, subordinate to the president.
I get that part. So I'm more speaking logistics and the energetics of this. The National Guard enters Chicago. We're doing a scenario. They enter Chicago. Who is who? We know the order was given by the president. Who is in charge of the National Guard within Chicago?
It's whomever the president has delegated the authority to. He could call the National Guard from Ohio.
Okay.
He could call the National Guard from Hawaii.
They're going to get their instructions.
They're going to get them, and there will be instructions
DC.
that will be given from the top down. Supposedly the governor, we would assume, the governor will be in that chain of command, and he will be required to execute those instructions. However, the president could simply go over his head and say, Mr. Pritzker, Governor Pritzker, you've been... You've shown dissent from what I'm doing. I don't know that you're a reliable figure here, and I'm going to issue my orders directly to these National Guard officers, especially if they came from Ohio, especially if they came from Kentucky. Governor Pritzker would have no authority over them whatsoever. He couldn't claim to be the commander-in-chief of the Ohio National Guard.
Well, now, what about the police department? I'm sure in any areas around the country that have a high crime rate, I am sure the police departments appreciate help. Do you think that would happen? That the police would be glad to see the National Guard in Chicago, or upset, or mixed?
Well, I think they would, number one, be quite happy to receive whatever assistance they could get, because they probably, if they were being candid about it, they'd realize the situation in Chicago has gotten out of hand in terms of their ability to control it sufficiently. And I cannot understand why there would not be protocols already. I haven't looked. In all of these large city police departments for situations in which the National Guard may be called in, and vice versa, the National Guard would not have protocols. Because we've had instances where this has happened earlier. The big Los Angeles riots, the Rodney King riots as they were called, right? National Guard had to come in to restore order in cooperation with the Los Angeles Police Department, because the Los Angeles Police Department was insufficient to do it. It was getting out of hand. So, I mean, typically the military people will have, file after file after file of proposed plans. If this happens here, then this. If this happens, then that. How will we liaise with the local police authorities? And theoretically, even, I suppose, the National Guard in Illinois already has that in its file in case Pritzker called them out to deal with this situation in Chicago or some other domestic violence situation.
Oh, so they're probably standing directions or orders or a blueprint.
Exactly.
From
Protocols,
history.
procedures we're supposed to follow.
Yeah.
Right, because they do plan ahead in the military, and I would assume the police do as well in a city as big as Chicago. The problem here is at the political level, probably not at the planning level, not at the implementation level. The police would be perfectly happy to have extra patrols of National Guard, have National Guard handling people who are detained, subject to arrest, while the police are doing other things, right? Going off with the police in their patrol cars, or adding patrol cars with National Guard soldiers in them, right? Deterrence, more boots on the ground on the streets will tend to limit drive-by shootings, adventitious carjackings, and on we go. Curfews that might be put on. You can imagine all the situations in which they need extra people to perform those functions, and they don't want to necessarily burden the police, who are more familiar with the area and the patterns of activity there. You want them on the streets actually suppressing the crime, not providing the deterrent effect. All right, so in that situation, it seems perfectly normal to me that a governor would say, yes, we have a problem. The governor, I'm not accepting responsibility for it. I didn't do this, but we have a problem that we can't control. The mayor of Chicago, I have a problem we can't control because the police have told me that. And therefore, I'm more than willing to have assistance from the government of the United States.
So how long do they stay? And what determines their length of stay? Whether it's an abuse of power. I'm mentioning this because people concern themselves with this. This is a concern. Well, if they go in, how long? Are they there forever? Is this martial law? And I do want you to address that.
It goes back to the president's determination of necessity. Right?
Talk about that.
Well, it's the statute. The president can do this. He'll take such measures as he considers necessary. So those measures would include calling up the National Guard, sending them in under some protocols or procedures, and then determining when they no longer have to be there.
However, what about the conversation that's going around that says that a governor has to invite the president for the president to go into the state with the National Guard? Where is that coming from?
Didn't I just read this statute? Does it say anything about a governor?
No. Where is that conversation or that narrative happening?
I don't know where they're getting this idea. They may be getting this idea from this other statute, which the Trump administration has been citing. I think it's the only one they've been citing. I read before. Get the exact language. It's this Title 10 U.S. Code, Section 12406. It says, orders for these purposes, that is calling up the National Guard and sending them into the states, shall be issued through the governors of the states. And it may be that people reading that language, orders for these purposes shall be issued through the governors of the states, to mean that the governors have discretion to refuse to execute those orders, or that the governors must ask for those orders to be issued before they can be issued. That's not what it means. It means when the orders come from the president, the governors are required to execute them, just as the statute in Illinois says that the governor has the duty to furnish the National Guard troops when the president calls for them. He doesn't have discretion not to do it. He doesn't have discretion to disregard what the president's done. He doesn't have discretion to change the orders according to what his view of the situation is. He has the authority in form of a duty or an obligation to execute those orders. So I think what's happening here is some people are reading this statute, which for whatever reason the Trump administration has been citing, and reading into it some kind of discretionary authority on behalf of the governor. And all I would say is if you read the statute, that actually applies, because it talks about the failure of the state is unable, fails, or refuses to protect the rights, privilege, or immunities, or to give protection to its citizens. That's the situation here. That's what's going on. So this is the statute that applies. This statute does not talk about the governor at all. It has nothing to do with, and why doesn't it? Because the premise of this statute is that the state is responsible for the problem. The state is unable, fails, or refuses to protect the right, privilege, etc. That's the governor. Everyone in the state authorities are the ones who are responsible for this problem. So the last thing one would consider under this statute is that the president has to go and ask for permission from the very people who are the cause of the problem.
Okay, so got it. And I'm sure the listeners get this. let's take the next layer of this, which is martial law. What makes the abuse of presidential power, if there is some, martial law? Where does it go from exercising presidential authority in the situation like this in the states, right? Sending in the National Guard and helping clean up the crime in an area that's out of hand and not being tended to properly, to martial law. Isn't it a slippery slope, or is it?
Well, in principle, there's no such thing as martial law under the Constitution of the United States. Right? Martial law is something that's exercised by military authorities, and that is the Army. The militia is separate from the Army. The Army and Navy provisions are found in 2 sections of the Constitution, and the militia provisions are found in 2 separate sections of the Constitution. And the President's authority as Commander-in-Chief is on the one hand over the Army and Navy, and on the other hand over the militia of the several states. And the Constitution allows Congress not to call forth the Army to execute the laws of the Union, but to call forth the militia. Very important distinction.
Well, we don't know that distinction. Most of us
Well,
don't
we should know the distinction because right there on the face of the Constitution.
And most of us haven't read it.
Well, that's not my fault. That's our problem in this country, right? Who is supposed to be governing this country ultimately? Declaration of Independence tells you. The people themselves, right?
We the people.
And the Constitution says, we the people ordain this Constitution, right? So it's the responsibility of the people to read and understand the Constitution. Then they wouldn't have this problem. They would see that the interesting thing about the Army is a contingent organization, right? Because Congress is given the power to raise and support armies. Fine. But no appropriation of money to that use shall be for a longer term than 10 years, 2 years, than 2 years. And another provision of the Constitution says no money shall be expended for any purpose without an appropriation made by law. What is the purpose of this 2-year limitation? Well, what's the length of Congress, the House of Representatives?
2 years.
2 years. And the idea is that every 2 years you get a new House of Representatives, and it will look at this Army and say, we don't like this. This is a standing Army. It's dangerous. We are not going to appropriate money for it. Or we're going to appropriate only a very small amount of money for it. And then that limits the Army, and the Army theoretically could disappear in that next 2-year period.
But people perceive, Edwin, the National Guard as a kind of quasi-army.
That, unfortunately, is the confusion that was built into the historical devolution of the militia. Because the militia are state institutions that always existed from the earliest colonial times, and then were written into the Constitution, the militia of the several states. It also appears in the Second Amendment, a well-regulated militia being necessary to the security of a free state, right? But what happened during the 1800s was people who theoretically, and actually legally, because the statute said so, had an obligation to perform militia service, didn't want to do it. Right? And they became, in a sense, even contemptuous of the idea that they were required to perform this military service because after the War of 1812, up until the Civil War, no one saw a need for it. And Justice Story, who wrote the opinion in Martin versus Mott, by the way, in his famous treatise, Commentaries on the Constitution, mentions this point. He says, the militia is the palladium of liberty, but unfortunately today, and he was writing in the 1830s, the vast majority of people are holding the militia in disregard and even contempt because they don't want to assume this burden of militia service. They don't want to go out and train. They don't want to be ready to be called forth. All right. So by the time of the Civil War, there was a real dichotomy in the militia, and it traces back to the Marquis de Lafayette. Remember him? Well, he was a French nobleman. France was allied with the American colonies against the British during the War of Independence, and he came over, and he was one of the, I would call him aides to George Washington, military aides to George Washington. And so he was, in a sense, both a French national hero and an American national hero. He goes back to France, and he was involved in the French Revolution. We won't get into the details of that. But finally, in the 1830s, he makes his last visit to the United States. And he lands in New York. and they had a festival, essentially, in his honor. And in his honor, the New York State Militia named itself the New York National Guard. Why? Because Lafayette had been in command of the French National Guard during the Revolution. And if one knows the history of the French Revolution and the history of the French National Guard, one might say, well, that was kind of a mixed bag, because he went through the terror and the guillotining of people, and then eventually ends up with Napoleon the Emperor. Right? But in any event, this is what they did to honor him. And then this idea caught on, and other state militias started calling themselves the whatever, State National Guard, okay? And I always thought that was peculiar because, of course, a militia is not a national guard. It's a state guard, all right? It's a state institution that Congress can employ, but it's not a national institution in the way the Army is. In any event, this caught on. Then comes the Civil War. Fort Sumter. What was the first military action that Lincoln took? Significant military action, because he was involved in the Fort Sumter business. He called out 75,000 members of the state militia to put down the Confederate rebellion. All right? Who were these people? Well, some of them were in the State National Guard who had been training, had arms, and so forth and so on. And others were just ordinary citizens who had this obligation, but they had never really fulfilled it. In any event, all sorts of people fight in the Civil War. 600,000 people are killed on both sides, approximately. And people are fed up with fighting in the United States after the Civil War. But the militias are still there, and actually they're operating under the same statute, the statute of 1792, the Militia Act of 1792. But there was this bifurcation. There were people in the state militias who wanted to function as an armed force, who wanted to be true militiamen, and they also wanted to be recognized by the Army as somehow equivalent with the Army in terms of an armed force. And they were in the State National Guard, and everybody else was doing nothing. And they actually lobbied Congress, the National Guard Association of the United States, lobbied Congress to get weaponry, to get equipment, to participate in training with the Army, and so forth and so on. And this went on all the way up to 1903. So this situation from 1902 all the way to 1903. But what had developed was now this bifurcation of the militia into the National Guard people who viewed themselves as an adjunct of the Army, and then everybody else who viewed themselves as, I don't want to do anything. Statute is passed in 1903, supposedly to deal with this, written by a congressman named Dick from Ohio. So it's known as the Dick Act historically. And it created what we now have as the modern differentiation between the National Guard, which is called the organized militia, and everybody else who was called in that statute the reserve militia, and then in a couple of statutes that followed, the name was changed to unorganized militia. Now what's fascinating was that after the statute was passed in 1903, there was a congratulatory meeting of the National Guard Association, this big lobbying group. And Congressman Dick was there, and also Elihu Root, who was Secretary of War, was there. And they gave speeches, addresses to these people. And Root was very much in favor of and had worked for this 1903 statute. And he goes on congratulating them for having lobbied successfully, gotten the statute passed. And he says, now finally, for the first time, we have given the correct constitutional basis to the National Guard. Not under the militia provisions of the Constitution, but under Article 1, Section 10, Clause 3, which states, and I shall read this, no state shall, without the consent of Congress, keep troops or ships of war in time of peace. So he recognized the National Guard were state troops as to which Congress had given consent to keep in time of peace through this statute. And that's what they are. And that's why everyone today recognizes, the statutes now recognize, they're an adjunct of the Army. And if you go back to the Revolutionary War period, War of Independence, actually before that, during the period, the colonial period, there were three categories of soldiers in the colonies and then in the independent states. One was the British Army. the regular army. Remember, the colonies were part of the British Empire, so this was their army, the British Army. And then they had provincial troops who would sign on, essentially by contract, to go off with the British Army to fight the French and the Indians, because you had that series of wars during the 1700s. And then the vast mass of the citizenry, the male citizenry, from 16 or so to 45, 50, whatever the age limitations were, they were part of the colonial militia in each one of the colonies. So you had those three things: the regular army, the provincial troops, which were raised as volunteers, and the militia, which was a draft organization. Comes the War of Independence, the British Army is now the enemy. Congress raises the Continental Army. This was the army for all of the members of the continent, as it were, right, excluding Canada. And then the states raised their own troops, which are called the state line, and because they fought infantry. I guess they had cavalry and artillery as well, but they called them the state line. So there was one from Rhode Island and Massachusetts, New Jersey, whatever. And then each one of the states had its own militia. And so these militia would be called up for short periods of time to fill in the gaps. And then Congress comes along. In the Constitution, Congress is given the authority over the militia for national purposes, execute the laws of the Union, suppress insurrections, repel invasions. The militia are still state institutions for their own purposes. And then there's this thing, and then there's the Army. Congress is given the power over the Army. And then there's this thing in between, the state troops, right, the provincial troops, the state line, which the Congress says, well, we don't want standing armies in each state because that might lead to friction between the states and perhaps would result in violence, right? We want that controlled, and the way to control that is to require the consent of Congress, because Congress would then pass some kind of comprehensive statute regularizing and authorizing and controlling it. So that's what the National Guard is. Congress has passed a statute, a series of them, from 1903 on, which have given the states to keep these troops in time of peace. And the condition there is, because Congress always applies conditions to its grants of power, these troops are going to be an auxiliary to the regular army. And that's why you found the National Guard fighting in France in World War I, National Guard fighting in Europe and the Pacific in World War II. What were they doing outside of the United States? The militia can't be called to fight in Bougainville, the Philippines, right, Belgium, wherever they were fighting in World War I and World War II. But the National Guard can be, because they are troops that are an adjunct, or what they call a reserve component of the regular armed forces. So that's the peculiarity here. But if you read the statute, this is where the thing becomes interesting from a kind of a lawyer's point of view. If you read the statute, it says the president, by using the militia or the armed forces. So whichever way you look at the National Guard, if you say, well, the Congress has said it's an organized militia, let's leave the constitutional questions aside. But on the other hand, the statute recognizes the National Guard as an adjunct of the armed forces, a reserve component of the regular armed forces. So whichever way you read this statute, whether National Guard is militia or regular armed forces, the president has authority over them. End of discussion. That's why this statute is so important, really, because it encompasses the problem, which is the dereliction of the states, and it recognizes the sweeping authority of the president, and it talks in the very language of the Martin versus Mott case, in which the Supreme Court already decided this question in principle. This is not a hard problem.
I get that part. I still want to go back to what I asked you about 10 minutes ago, which is I appreciate you going through the history because most of us don't know it. Mm-hmm. Okay? Where does martial law come in? Like right now in the United States, where would you, Dr. Edwin Vieira, be concerned that what we're witnessing is martial law versus the National Guard going in at the president's orders to clean up a crime-ridden area or areas?
Well, you could have a problem of National Guard. You could have a problem of martial law even with the National Guard. Because martial law really is defined as the arbitrary dictates of the military commander on the scene. He's not bound by things like the Bill of Rights. He's probably not bound by some of the statutory limitations that might be put on the National Guard. That's true, honest-to-goodness martial law. We've never had that in this country, and there's no provision for it in the Constitution of the United States. Because even the president, as commander-in-chief, is subject to what? he is subject to the call of the Congress. And here's the important part about this. Let's see. Let me read this because most people don't understand this either. Congress has the power to make rules for the government and regulation of the land and naval forces. And that's one of the 3 provisions that deal with the Army and the Navy. It also has powers to provide for organizing Army, disciplining the militia, and for governing such part of them as may be employed in the service of the United States. So the ultimate authority for what can be done with these forces depends upon some statute of Congress. The president does not have arbitrary authority as commander-in-chief to say, well, here's how these forces are going to be used. He has to look back to regulations that have been written by Congress. And one assumes, one hopes, that these regulations will be consistent with the limitations on Congress's power. They're not going to violate the Bill of Rights. They're not going to violate any other limitations that Congress may have in Article 1, Section 8. Martial law, on the other hand, looks the other way entirely. It says, no, it's the commanders on the spot who make up the law as they go along. And it's subject to the chain of command within the military. So maybe some colonel decides to do something. He's subject to the general, but the general can be just as arbitrary as the colonel. And theoretically, you could go to the commander-in-chief, the president. He could be just as arbitrary as the general and the colonel. But the answer is no, because the president and all of these other officers, including the ones in the National Guard, are subject to the regulations that are made by Congress. You have to find a statutory authority for it. So we can't have martial law in this country.
Did you say can't?
We cannot.
Right.
We cannot have martial law in the true sense of martial law. Now, we can have the regulations of Congress and statutes of the United States executed by these military authorities, which, of course, the National Guard are. That is not martial law. That's the execution of the laws of the Union as provided by Congress through these authorities, these forces, to which the president has been given the authority to call forth. By whom? By Congress, right? Subject to its constitutional authority and as provided in a statute. So we're not dealing with martial law here. Now, the problem, of course, is what happens when you put some military officer, boots on the ground, he's there, and he has it in his head that he can simply willy-nilly give whatever orders he wants. Right? That's where the problems arise. And there has to be, obviously, supervision. And that's where you would hope that there would be protocols dealing with the interaction of the police and the National Guard, so we wouldn't have that kind of friction developing where some officer in the National Guard says, well, I'm going to take it on my own recognizance to give orders to these people the way I see it, the way I think it should be done, notwithstanding that I myself am subject to rules of engagement and other. And there's an example of it, as a for instance. You got the troops in Iraq, Afghanistan. They had very specific rules of engagement. If they saw someone that maybe they thought was carrying a rifle, or maybe even was carrying a rifle, a lot of people in Afghanistan and Iraq legally were carrying rifles, they weren't simply entitled to shoot those people down. They had to wait until those rifles were pointed at them or there was some kind of hostile act before they could engage in a firefight. And so you would imagine that would be restrictions even more restrictive than that would be applied to the National Guard and in their relationship with the police. And I'm sitting here admitting that, well, those things don't always work on the, from moment to moment. But that's where the discipline and other, legal restrictions are supposed to come into play.
What happens if the head of the police is instructed by a governor not to cooperate?
Well,
God forbid, but
I would imagine there are a couple of difficulties because of number one, if the National Guard comes in, they might simply take control of the entire situation. All right.
What does that mean?
Well, the order would come from the president to even these police officers or police commissioners or whatever.
What would happen to them?
Oh, I think they, in the ultimate sense, they could be arrested, interfering with the National Guard's activities.
Is that a federal crime?
Oh, yeah. Yeah, I think it would be.
Okay.
I think it would be. There are quite a few of them in terms of obstruction, interference, and so forth. But I don't think that would happen. I have a feeling that
they probably appreciate the help, like
I have a
in
feeling.
D.C. Remember
I have a feeling
D.C.
the Chicago police, if they were kind of told in the back room, here's the situation, and Governor Pritzker were telling them to do something to disregard the president's orders or the protocols with the National Guard, they would simply do what they were told. There's an interesting question here, too. I don't know exactly how they categorize the Chicago police in Illinois. But assume this happened in Virginia. Assume that it was Richmond, Virginia, that was the city. Everyone in Virginia from 16 to 55, every able-bodied resident, male and female citizen, is a member of the militia, simply as a matter of law. And you're in the unorganized militia unless you're in the National Guard, or the thing called the Virginia Defense Force, which is an adjunct of the National Guard. So that's the police. The members of the police are not exempted from membership in the militia. So theoretically, if this were to happen in Virginia, and the Richmond police were to say, no, we're not obeying the Virginia National Guard, I take it the governor would simply say, well, I'm calling all of you out as members of the National Guard, which I can do. And if you disobey, you're all going to be court-martialed.
Now, what does court-martial mean?
It's just subject to military justice, which is, I would say, somewhat arbitrary. You go in front of a court of military officers under the Uniform Code of Military Justice. They have their own judicial procedure, similar to ours in many instances. But
do people go to jail for this?
You could go all the way to execution. Dereliction of duty, cowardice in the face of the enemy. I mean, think of it. There was only one American executed in World War II for desertion. Eddie Slovak was his name. And it was an interesting question whether he should have been, because he may have been a little mentally defective. I don't know. But there's that one example. So it could happen. It's there in the code. Now, let's face it, not going to come to that consequence. But I think in the Virginia case I'm giving, if you had recalcitrant police, the police force said, well, we're simply not going to do it. We've decided we're going to do it because the mayor of Richmond has told us we ought not to do it. The governor would simply say, well, you're inducted immediately into the militia. You're called up in the militia. Now you're subject to court-martial. And I give you the example. Now, I'm too old. The Virginia statute says people from 16 to 55 can be called up by the governor to execute the laws of Virginia, suppress insurrections, repel invasions. So we might have this situation in Richmond, right? Can he call me up? Well, initially, no, because I'm over 55. But there is a provision in the Virginia Code that says he can call anyone else if necessary. And then those people would be drafted and they would become part of the militia as a result of this provision. So theoretically, the governor could call me. I'm not sure how he'd do it, in email or something. And he'd say, I want you to respond. I want you to report to some place in Henrico County, outside of Richmond, on such and such a day, right? And you're going to get your marching orders.
But you're over the age limit.
But the statute says that he can call me anyway under some circumstances.
What would that be? It'd have to be an emergency.
Well, all right. That's what he's saying. I can't control Richmond. It's out of control. They're burning the city down. I'm going to call everybody, including you, because you're a constitutional scholar and I want you there on the scene. So I want to call you up. I want to force you to be there. And I say, Governor, I just ain't coming. All right? I'm staying home. They'd send somebody out to arrest me and try me under the Uniform Code of Military Justice for dereliction of duty. All right? Just as if, you're drafted and you don't show up, what do they do to you? Why did people during the Vietnam War who were subject to the draft flee to Canada? Because the alternative was arrest and imprisonment. All right? So I don't know what the exact provision is under the Illinois Code. They probably have something similar to that. For someone who refuses to perform militia duty, he can be subject to military discipline. And that would be the police, because the police, at least in Virginia, no police, the sheriffs are. The sheriffs have an exemption because they're constitutional officers. But the policemen, who are statutory officers of the various counties and towns and cities, they have no exemption from militia duty. So if any of them said, I'm not coming, I'm not doing it, I'm not following the National Guard, if I were the governor, I'd say, well, you, and you're all being inducted into the militia, and if you don't follow these orders, you'll be arrested. Since
a critical mass of people don't know that, they could just say, well, sue me.
How many lawyers have I talked to? And I do this facetiously with a lawyer. I say, sometimes we're talking about gun control and the Second Amendment, right? And I say, well, to what militia do you belong? Lawyers. And they look at me and say, I'm not one of those crazy guys running around in the woods in camouflage outfits with AR-15 rifles. And I said, no, what legitimate militia. To what legitimate militia do you belong? He says, I don't belong to any. I said, don't you understand there's this statute, 44.1 to 44.145, there's like 140-something sections of this militia code. And one of the things it says is that guy, if he's able-bodied and he's between the ages of 16 and 55, or possibly older, such as myself, he's a member of the militia, and he can be called out by the governor to repel invasions. The Chinese Women's Army lands in Roanoke, and this lawyer in Fairfax can be called out, given a gun, he probably doesn't have one, but given a gun, and sent down to fight the Chinese Women's Army. And he can't do a thing about it, except desert, I suppose, in which case he'd be apprehended and tried under military tribunal. And so they're surprised. I mean, I run into these people, and it's like a look on their faces if it never dawned on them that this was there. I said, well, start with section 44-1 in the Code of Virginia and just read the next 100 sections, and you'll see what happens here. You can be called out to repel invasions, in which case you might be killed. Suppress insurrections, well, you might also be killed there. Execute the laws, well, it depends upon who the criminal is. That's a dangerous proposition, executing the laws in some circumstances. So you can be put in a position under this statute you didn't even know you were obligated. And the next thing you know, you're fighting the Chinese Women's Army, in Hampton Beach. Lawyers. Lawyers.
Well, you're the one who told me that in Harvard Law School, they weren't actually teaching constitutional law.
We never read the Constitution all the way through.
That's staggering.
I thought that was fascinating. I thought with the first class, the professor would have held up the Constitution and said, well, today is Wednesday, and we're coming back on Friday for the next class. Between now and Friday, I want you to read this document, and we'll discuss the basic provisions and the outline of how it functions on Wednesday. But please get familiar with this. Oh, no, we started right away reading decisions of the Supreme Court about the Constitution. And there's a difference between reading the Constitution and reading what someone has said about the Constitution. They don't always jibe.
I just have a question before we get to this, the other half of this. Is the Supreme Court a constitutional body?
Well, yes. Actually, it's the only court of the national government that's named in the Constitution. The judicial powers in the Supreme Court and such inferior courts as Congress may create. And then Congress is given specific power to create tribunals inferior to the Supreme Court.
So what if the Supreme Court could, a governor, let's say Pritzker, go to the Supreme Court over the President of the United States going into Illinois with the National Guard or calling upon the National Guard and saying he must be stopped, this is an emergency, blah, blah, blah. Can the Supreme Court rule on this?
Well, let's take a situation. The governor of Illinois, he just goes beyond the district court. He goes beyond the appeals court, and he says, I'm going to take this case directly to the Supreme Court because the Supreme Court has ultimate jurisdiction, and this is, quote, unquote, an emergency, whatever that means, all right? And I'm going to seek from the Supreme Court a petition for certiorari and a writ of prohibition. And I focused on the writ of prohibition because that's an order from the Supreme Court to some official below. Stop doing what you're doing. You're prohibited from doing this for some reason. So if I were the governor's lawyers, I would say, let's go for the writ of prohibition because that's the clear one. We want to stop this president from doing what we believe is unconstitutional or in violation of his statutory authority. And the first question is, well, would the Supreme Court even take it? Because that's discretionary with them. They're not required to take such a petition. It could be brought on behalf of the state of Illinois, in which case it would be in the original jurisdiction of the Supreme Court. But we had that famous election case with Texas and so forth.
Right, back
Georgia,
in 2020.
Which was in this original jurisdiction because we don't hear that either. No, I think that's unconstitutional.
You have to explain to the public because you just went back in time and refreshed the public.
Well, the Constitution provides that the Supreme Court has two kinds of jurisdiction, original jurisdiction and appellate jurisdiction. Appellate jurisdiction means cases come up from lower courts. Original jurisdiction means the case starts in the Supreme Court. And it says those cases involving ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Shall have. That's mandatory language, shall. You shall do this. You shall exercise this. In all other cases, the Supreme Court shall have appellate jurisdiction with such exceptions and under such regulations as the Congress shall make. So Congress determines the extent of the appellate jurisdiction. And the appellate jurisdiction is things like petitions for certiorari, various kinds of petitions, when there were actual appeals, required appeals.
Go back to Texas, though. Bring the audience
But that's secondary.
back.
That you go up through the other courts. You go up
Right,
through the
but just
district
fill
court,
the
appeals
public
court.
in. What are you going back in time and referring to when you talk about Texas and the election?
Well, that was the case in which Texas was challenging the electoral college votes. And it was a state, it is a state, and it was suing Georgia and one or two other states. Can't remember. There were more than one state on each side. And therefore, a state was a party in those cases on both sides. And therefore, that case came within the original jurisdiction of the Supreme Court. And the Supreme Court said, well, we think we have jurisdiction not to hear these cases, so we're not going to hear it. The Constitution says it shall, not may. There's a difference between those words legally. And especially given how important this jurisdiction is, because one of the reasons it was put in was to prevent conflicts between the states from getting to the point where armed forces might be used. And also with foreign countries, right? Foreign countries through their ambassadors are suing in the original jurisdiction of the Supreme Court. Consequence of the court not hearing that case might be some kind of international conflict which would rise to the level of, well, something along the line of war, let's say. So one would think that jurisdiction, anyone reading that provision will say, well, if such a case comes in front of you, it's important enough you have to take it.
So
Especially the electoral case.
Right. But you were using that in reference to a governor of Illinois possibly trying to take the case to the Supreme Court.
Well, it would be state of Illinois. He'd be
Right.
bringing the case on behalf of the state of Illinois.
Right.
State of Illinois, I'm the governor. We're bringing this case on behalf of the state of Illinois. We can't be coerced by the president to use the National Guard. That's his case. So he goes in the original jurisdiction of the Supreme Court seeking what would be the relief? I would say writ of prohibition. Supreme Court telling the president, you can't do this. You don't have the authority to do this. Okay. Now the question would be, assuming that the Supreme Court doesn't take it, then Governor Pritzker would be relegated to bring a case in the U.S. District Court. You'd have to start from the bottom and hope that district court and the appeals court, if there were an appeal, would side with him. They would clearly have jurisdiction. They would not have discretionary jurisdiction. Right? We don't know. But assume he goes to the Supreme Court and assume the Supreme Court says, well, it has three choices. It can refuse to take it, but assume it takes it. Now it has two choices. It can say the president's doing what's authorized by the Constitution and the statutes, or he isn't. If they say he is, that's the end of Pritzker's case. And then the courts would be required, if Pritzker still persisted, the president could go into a U.S. District Court with a case against Pritzker. All right? Turn the litigation thing around against him. But assume the Supreme Court erroneously said, no, the president doesn't have this authority. What should the president do? Do it anyway. That would be my advice to him. Just do it anyway. All right. Martin versus Mott, this is absolutely clear. At some stage, the president has to assert that there is authority in the other branches of government, the executive branch and the legislative branch, Congress, not to be required to kowtow or mechanically acquiesce in an erroneous decision of the Supreme Court. Because the Supreme Court's authority is limited to a case in controversy in which it has first jurisdiction, and secondly, in which it actually enforces the Constitution, not some wild idea it has about the Constitution. Otherwise, it would be the Constitution. Or let me put it another way. 5 members of the court would be the Constitution. 5 changing members of the court would be the Constitution. And we know that isn't true because the Supreme Court reverses its own constitutional decisions from time to time.
It happened with you.
Well, I'll tell you about that, but just in principle. So here we have a constitutional decision that says A, and then we have a constitutional decision later on that says B, the contradiction of A. Which one is correct?
Depending upon the time. I mean,
Well, but it can't be. One or the other has to be correct, right? Because here's the Constitution. The Constitution hasn't changed.
yeah, the Constitution
right?
is correct, but
But I'm saying A could be correct, or B could be correct, and A would be incorrect, or both of them could be wrong. There's that third possibility. Both of them could be wrong, all right? So when the Supreme Court talks about its constitutional authority, we're talking about speculation. And the speculation only applies to the parties before the court, Jones versus Smith. So if they decide a case between you and me, it binds you and it binds me. But it doesn't involve that fellow across the street, Jones, or that fellow in the other state, Smith, because we're not parties to the case. The most you can say about this decision binding you and me is that with respect to Jones and Smith, it's an advisory opinion. It suggests to Jones and Smith how their cases might be decided. But maybe not. Maybe they have better lawyers than the two of us had. Maybe the facts are slightly different. Maybe the composition of the court, we won't even say the composition of the court has changed. Maybe they've gotten smarter clerks to look up the precedents. Maybe they reviewed their earlier opinion and said, gosh, we were wrong in that one. We have to change our minds. I'll give you my example. 40-something years ago.
this is an incredible story. Everybody, listen
I
up.
don't know, maybe
This
it's
is
typical.
wild.
I had a case called Abood versus Detroit Board of Education in the Supreme Court, and it had two questions. The first one was, public sector unions should not be allowed to collect money from non-union employees as a condition of employment at all. And the second aspect is, well, if you're going to agree that they can collect some money, it should be limited to their costs of actual collective bargaining and not these other extraneous things that the unions do. So the union should only collect a part of their dues because part of their dues money goes to these other things. So the Supreme Court said in its typical Solomonic, Solomon splitting the baby in half, well, they can collect money. We're going to allow them to do that, but it's only to this limit. Well, I didn't agree with that, so I litigated other cases and won other cases, whittling that down, requiring the unions to have procedures and accounting methods and so forth and so on. And there were a number of other people around the country and organizations didn't like it either. And they kept litigating and litigating and litigating. 40-some years later, the Supreme Court in a case versus Janus, versus I think it was Serious Employees, some public sector union, said, well, we were wrong in Abood. It was a big mistake. And now we're reversing ourselves 40 years later. Now, this didn't help all the people who paid money to the union during those 40 years, right? They had no claim. They're just out. They're gone, right? But finally, this court, it was a different bunch of justices, obviously. They finally recognized this opinion was untenable. Now, the reason I think it was ultimately untenable, besides it being an unconstitutional decision, was that they were having this litigation constantly. And they were trying to square the circle. They had a decision over here which really didn't solve the problem. And people were constantly nibbling at the edges of this decision, saying, well, what about this? What about this? What about this? And finally they gave up and said, we can't figure this out. We can't square this circle. We can't provide Solomon's answer to splitting the baby. And so we're just going to throw the baby and the bathwater out together. It's gone, all right? Well, now what does that mean? That they were wrong 40 years ago and for 40 more years, 43 or 44 now. And for all of that time, for 40 years, the country was involved in an unconstitutional situation involving not just the Detroit Board of Education, but all these other state boards of education that were doing the same thing under statutes that had been passed that then allowed for these kinds of collection of money. There was this huge mess out there. Well, was the Constitution wrong all this period of time? No, they were wrong. And so after the President of the United States said, I have an emergency, quote-unquote, emergency situation. I have to do this. I have statutory authority from Congress. I have constitutional authority here. I have Supreme Court authority from Martin versus Mott, which is exactly on point in principle. And now you're telling me, a different bunch of justices, that all these things should be disregarded? No, I'm not going to do that. Try to enforce your order against me. Or are you going to send the U.S. Marshals to arrest me?
Who do the U.S. Marshals work for?
Well, supposedly they work for the judiciary. But when they show up at the White House, I guess the Secret Service wouldn't let them in. if they showed up in Chicago to tell the commander of the National Guard to disregard the president's directive, I don't think he'd follow it. But it would create a very interesting situation, because you know who did this in the past? Andrew Jackson, right? The Cherokee exclusion case. And the Supreme Court ruled one way, contradictory of what Jackson wanted to do, and decision by Chief Justice Marshall. And Jackson said, Chief Justice Marshall has issued his decision. Now let him enforce it. And nothing happened, because the court has no real enforcement mechanism. That's why I think if Pritzker did this, if his lawyers were, what shall I say, daring enough to tell him, let's take this directly to the Supreme Court, the Supreme Court would punt it, right, and let him go to these lower courts for however long that took. Because during the course of that litigation, what would be happening? The National Guard would be straightening out the situation in the streets of Chicago, and then it would go away. They're not going to be there for years. They might be there for a few months, right, until they get it primarily under control, and then they're going to melt into the background.
Ladies and gentlemen, we're going to go to a quick break, and we'll be right back with Dr. Edwin Vieira. What if you found out that you could form a question in such a way as to expedite the resolution of that which is seeking resolve in your very question? When you ask a question, you're setting something into motion by the very formation of that question, which acts like a vacuum, and that vacuum seeks to be filled. The more you're able to form a question with the elements of the question seeking its very construct, the faster you'll have solutions, discoveries, direction. It could be said that question formation is a science that has to do with energy in the vacuum and solution delivery. It has to do with physics, electricity, magnetism, forming something in such a way that the answers, the direction where the discoveries and the answers are, where you may or may not be looking, can flow into that question, into the construct, and then when you hold it with others for it to arrive, it brings in an urgency, it brings in expeditious answers to what you're looking for. This is one of the most important teachings of today, question formation. And don't be confused. This is distinct from AI prompts. While AI prompts are important, when you are going into AI prompts, you are going into a digital translation of data. You are not looking into the vacuum of the universe, the entire universe, for guidance and direction with respect to your question and your inquiry. Totally different. Some people would say, well, inquiry is inquiry. No, it's not. Or they may say that's not a big deal. Inquiry is one thing. If you're doing it digitally, it is totally different than question formation into the vacuum, into the magnetic field, into the electrical universe, which brings in direct translation, direct data in a way that AI cannot. For those of you that are interested in learning this, I'm available to teach it to you, whether it's online or at your location, to leaders and agencies and organizations and groups and communities. Question formation is a science that everybody needs to learn and develop and become proficient in. Go to rainmaking.ch, the Rainmaking Company, under training, under question formation. And back to the show. We are back with Dr. Edwin Vieira, and I wanted you to share what you just shared with me, and then I want to talk a little bit about Charlie Kirk and some of what's going on in the country there.
This idea that the national government, the president, or maybe his subordinates, Secretary of Defense, Secretary of War, they call him now, people with authority over the National Guard, haven't done this in the past, that this is some very peculiar or unique situation that's arisen, is nonsense. Because if you go and look up Title 10 of the United States Code, Section 252, which is entitled Use of Militia and Armed Forces to Enforce Federal Authority. Look that up in the United States Code, and you will find executive orders that have been written over the years using this statute. Here's one with the state of Arkansas in 1957. State of Mississippi, it was used in 1962. State of Alabama in 1963. Another one in the state of Alabama in 1963. So who were those people? Dwight Eisenhower and then John Kennedy, right? So we're talking about people. I mean, President Trump has this, reputation as being some kind of extreme figure. I don't think you could apply the epithets that are used against him to either Eisenhower or Kennedy, and yet they were exercising the authority to use National Guard troops within those states. Now, that was during the Civil Rights era, the Civil Rights problem. But it was the same type of situation, that those state authorities were denying large segments of their population certain civil rights and constitutional rights, especially related to public schools, or in the case of, Alabama, it was the University of Alabama, so it was a higher level, right? And the governors stood in the way. If you remember, I remember at the time, there was Governor Orville Forbes, governor standing in the schoolhouse door to prevent the little black children from coming into elementary schools. And then the governor of Alabama, George Wallace, saying he was going to do the same thing to prevent one particular black student from going to the University of Alabama. So we had situations exactly akin to this. The ultimate predicates, the civil rights that were involved, were different. But the conflict of authority, or the challenge of authority by the governors to the national government, ultimately the presidents Eisenhower and Kennedy, was exactly the same. And who prevailed? Eisenhower and Kennedy in sending in the National Guard. Forbes, in fact, was the one, he called up the National Guard in order to help him enforce his segregation theories. And Eisenhower came forth and federalized the National Guard and took it away from him. I'm not sure, I think maybe Wallace backed down before that happened. But Forbes thought that he could control the National Guard as a superior to the President of the United States, and that was ruled against him. So we have the same situation here, just a different set of civil rights involved.
The federalization of the National Guard means what compared to the National Guard that we're aware of today that we refer to in conversation? What's the distinction?
Well, the National Guard are units of the state establishment.
Right.
So we have 50 of them. There's one in each state, right? But they have this overlapping responsibility as a result of the consent of Congress to allow the states to have these troops at all.
I mean, there's only 50 per state?
Well, there's one in the District of Columbia, all right? So there's one in each state because they are the troops that the states can raise in time of peace with the consent of Congress. And part of that consent of Congress is these National Guard troops will act as adjuncts or reserve components of the regular armed forces. So when people sign their enlistment contracts, they're agreeing to this. It's a contractual obligation, all right? And they're stuck with it. So they have this dual authority, and the president is in a position where he can exercise superior authority over the governors.
Okay. So you can have the National Guard called in from several states to come into, let's say, Chicago, if necessary.
Absolutely. In fact, if the president wanted to put Pritzker in a difficult position, he'd say, you're just out of this. I'm not calling the National Guard from Illinois. I'm calling the National Guard from New Mexico and Arkansas and whatever, and they're coming in. And that's the end of it. Because there's no limitation in the statute as to which components of the militia or armed forces can be used.
And does the National Guard, if the president decides to federalize the National Guard, is that a formal process?
Oh, yes, he has to give a formal directive.
In other words, the federalization of the National Guard, is that happen through an executive order? Is that through a speech? How does it get structured?
Oh, well, he'd probably have to issue a proclamation or executive order. I'm not sure exactly what their protocol is, but there would be an official document saying, I'm doing this pursuant to this statute, and then whatever regulations that do you want him to enforce pursuant to that statute? And he delivered that to the governor. That's his whole point of delivers it to the governor. He delivers this to the governor, and then in principle, both under Illinois law, if we're talking about Governor Pritzker, and under federal law, the governor has to take that order and execute it, enforce it, not try to avoid it or
But who
or refuse.
manages? My question is, if there are governors which are in opposition, who will not cooperate with the orders. First of all, how will the president know that a governor is cooperating with those orders? Where's the oversight to make sure
I
to
imagine
secure that cooperation?
if I were the president, I'd write my directive to the governor saying, please tell me how you are enforcing this by such and such an hour. You're getting this at noon, and I want a response from you from 6 o'clock.
And if he doesn't have it?
If he doesn't have it, then I go to the adjutant general, probably.
Who's that?
He's the next fellow under the governor. In all states, it's this adjutant general of the...
Okay, and if that person doesn't...
Oh, he'd be arrested immediately.
Who arrests that person?
Whatever National Guard people I had on the scene. The military police would show up and he'd be arrested immediately.
What if security tried to stop them from arresting that person?
Well, who's security?
The governors.
Well, I'm not talking about the governor. I'm talking about the adjutant general. Okay. Oh, the governor of the state police? If the state police, I assume that would be his. I assume that would be his security. The state police at the Capitol.
Don't all governors have security?
Well, I don't know whether they have security. The state usually have the state police are the people who are their security. Maybe they have other forms of security. Well, I guess they would also be arrested as in violation of federal law.
All these people are going to get arrested if they don't.
Well, we're talking about violation of federal law. What are we talking about here? I mean, this is not a game that's being played. The guy's in direct violation of federal law. It happens to be military law. I guess they'd send the military police after him.
How many tanks could go into I'm from California, so I'm thinking California, but into Chicago if necessary, if the 50 National Guard were utilized? Only 50? Do you think there's more National Guard per state?
What do you mean, people?
Yeah.
Well, in Virginia, it's a little less than 10,000.
Okay.
I don't know how many thousands
I don't know.
there
You
would
said
be.
50 about something.
No, there are 50 states. There are 50 National Guards.
Okay,
There's a National Guard in each state.
All right, that's
and then it depends upon.
I was like, 50,
then it depends
not a
upon
lot.
the population of those states as to how many actual people they have. Now, in Virginia, that 9,000 something. I looked at this a couple of years ago. It's on their website. It was divided between the Army National Guard and the Air National Guard, Air Force National Guard. Now, I can't imagine the president would be using Air Force personnel. What, are they going to bomb Chicago? Probably not, right? No. So maybe it's 4,000, 5,000, 6,000, whatever it is. The Army is bigger than the Air Force National Guard. So it would depend upon how many people he wanted to send in. Maybe 1,000 would be enough. Because I would think that there would be some coordination with the Chicago police, the head of that organization, saying, well, what's your deficit? How many people do you think you need in these categories? Communications, deployment on the streets, detention of suspects. We're giving these categories. How many do you need? Do you need, besides security personnel, maybe you need medical personnel. Maybe you need people coming in with I won't say tanks, but they can run certain kind of armored vehicles, MRAP type vehicles through the streets, just as the SWAT teams do in many large cities, right? How many of these do you need? They'd come back with a response, and the National Guard people would say, fine, we'll mobilize this, and they'll be there tomorrow morning or tomorrow afternoon, or this unit will be there tomorrow and the one will be there the next day. This would all be worked out, and probably has already been worked out in principle.
Okay, so here's my next question, and then I want to go to this next part of our discussion. What actions is the National Guard allowed to take with civilians who are committing crimes? And where does their authority go? They're sent to Chicago. We're really drilling into this. They're sent to Chicago. They're there in different areas that are high crime or very difficult and having a lot of difficulty. What can they do? What can't they do? What are they authorized to do in action?
Well, I think they would be authorized, number one, to execute the laws of the city of Chicago and the state of Illinois in conjunction with the police. So you're not going to allow them to engage in unconstitutional searches and seizures. You're not going to allow them to interrogate witnesses in violation of the suspects in violation of the Fifth Amendment. You're not going to allow them to disregard suspects' demands to have attorneys before they're questioning. They're going to be subject to all of the Bill of Rights limitations that would apply to the police. They're not going to be allowed to use force beyond the limits of what the police would be allowed to use, unless it turns out to be some kind of riotous situation in which arsonists and so forth literally could be shot. That was always the law. I'm not sure whether it is in Illinois. But those two, looting and arson, looters and arsonists was always subject, theoretically, to be shot on sight. Right? Maximum force to be used against those people. I doubt that that's the case with respect to looting. I wonder if it still is with respect to arson, because arson is an extremely dangerous crime. All right, but they would be operating, their rules of engagement would be the same rules of engagement as the Chicago police.
Okay.
Unless the situation deteriorated and it became some kind of really violent riot with arson and so forth and so on, and then they would probably go to something that was a little more extreme.
Okay.
But that would be a self-protective mechanism, too.
Right. How do you feel about, and what do you think about what has unfolded in D.C. in terms of any transformation in the location and the fact that the mayor, while I think many of us already feel she's never liked Trump and was quite antagonistic to him, is actually acknowledged that it was very helpful?
Well, she saw the handwriting on the wall. And the first handwriting on the wall was she couldn't do anything about what he was going to do. She could talk a game, but she couldn't keep him from taking those steps. Some lawyer finally whispered in her ear and said, well, you can say whatever you want politically, but legally we have a problem here. We can't stop him. And then there were the results. And I'm sure if the results hadn't been positive, she would be the first one saying, well, look what happened. Trump talked a good game, but, right? So she had to acknowledge that the results were effective. And I imagine even more so in Chicago, the mayor of Chicago and the governor of Illinois would have to, assuming that the same process is followed, right? Assuming that they are successful in using the National Guard, that they would eventually have to admit, yeah, this was probably a good idea.
Okay, now I want to ask you about another part of what happened in D.C. Where you're at, where is the Constitution at about removing homeless people and their, accoutrement, their tents and in parks and on sidewalks and all that. What do you have to say about that?
Well, that comes down to what the local ordinances are. All right, so again, we're talking about a situation where these homeless people are actually violating some local ordinance, which is this big problem that we're discussing, right? The failure of the local authorities to enforce these local ordinances, and probably to the detriment of the homeless people. Right. Because many of them need psychiatric care or they need medical intervention because of drug addiction or whatever. They've got all sorts of other medical problems as a result of living that life, if you call that a lifestyle, living that way. And so probably the best thing that could happen to them would be taken to some kind of center where they could be triaged in a sense. The drug addicts here, the people with other diseases here, and so forth and so on, and dealt with effectively by medical psychiatric personnel.
Do you think they were really being helped, or do you think they were being dumped?
Well, I think that's what's going on in this country. The second is probably the description of these poor people. They need some kind of assistance, and they were never getting it. And there we come back to that statute. Here's a segment of the population which is not receiving protection in the broad sense for the problems that they are causing themselves and that they are causing to others. The city administration, for whatever reason, is incapable of solving this problem. Someone else has to do it. It's the capital of the United States, for heaven's sake. All right? Now, we don't want to treat these people with a lack of compassion, obviously, right?
Right.
They're not going to be put in some kind of detention centers.
Well, that's why I'm asking where you're at, because a lot of people are mixed about how people who are homeless are treated, but also people that are not homeless, how they're treated is pretty bad, having to put up with what's going on the streets.
Well, that's
and in cities.
Well,
and
that's,
so it's
that's exactly the two sides of this coin.
Yeah.
You have one segment over here which is not receiving protection in the sense of help that they may need. And on the other hand, you have these people who are not receiving protection from the effects of the people who are not receiving protection. So it's a doubly complicated situation. And one has to have sympathy for the homeless people, I assume. Some of them are responsible for their own state of affairs because they've chosen to be drug addicts. They followed that unfortunate course of life. But that doesn't remove the problem that they need some kind of care and assistance. And not leaving them on the street is totally insufficient. Something else has to be done. Simply because they create a problem for this other segment of the population. And they're a breeding ground, obviously drug addicts are a breeding ground for all the crimes connected with drug trafficking, human trafficking, right? People that are prostituting, women are prostituting, girls prostituting themselves in order to obtain drugs. So the whole thing feeds on itself. And if the state officials, for whatever reason, are not willing to deal with that homelessness problem and all the crime associated with it, then it will fester and spread into these other areas of the community. So you look at that situation in D.C. or any of the major cities and you say, this has gone as far as it's gone because of the dereliction of duty on behalf of the local authorities.
I can tell you that Los Angeles is in big trouble.
Oh, gosh, I would think so.
It is so bad what has happened.
I would
it
think
has
so.
deteriorated into something I've never could have imagined.
And it wasn't the federal authorities who did that. It was the state and the local. And at some point, if the state and the local had been paying attention to what was going on, they should have come to the federal authorities and said, we can't handle this. We've got to get some assistance. Now, they might have gone, the governor might have gone directly to his own National Guard and brought those people in.
Yeah.
Right? But the governor was part of the problem.
Mm-hmm.
Certainly Newsom. I think Newsom is definitely part of the problem. Pritzker, I'm not so sure. Right? It may be just a political thing with him that he doesn't want Trump interfering. But on the other hand, he's not solving the problem.
Do you think it's possible to clean up Chicago, as an example, the same way D.C. has been cleaned up?
It's a much bigger problem.
Yeah, because it's a bigger place.
It's a bigger place, and the underworld is more thoroughly ensconced there, and the level of violence is higher even than D.C.
Really?
I think so, yeah.
Wow, that's saying a lot.
Well, because I think there's a lot of violence that goes on that is never reported. The rapes, the robberies on a street corner, right? You think of the black community, which doesn't, to a large extent, doesn't trust the police at all anyway, right? Because of the way they've been treated. One black man robs a woman, steals a woman's purse on a street corner at night in Chicago. Is she necessarily going to run to the station house and report that to the police?
No, probably not.
She lost $50 in a compact, right? Or whatever, or something trivial. She doesn't want to get involved because maybe they're going to look up her record and start blaming her for something else, right? Because she now has to identify herself. So I would imagine there's a lot of that low-level criminality. And that's, to a large extent, it's not the matter of, I believe, not the matter of one adventitious criminal. They're gangs that do this. And these two people have this street corner, these two people have that street corner, and they wait for the appropriate set of circumstances, and they rob somebody.
We're approaching very soon what will be the winter.
Yeah.
And the winter is severe and horrific in Chicago, a place like Chicago, and in other parts of the United States. Just terrible. So how would the National Guard, if they're going to get in there and do anything, they better get in there soon.
Or they'll need more people.
For sure.
Or they'll need more people, yeah. So the sooner they get...
We're talking freezing, absolutely freezing weather.
Yeah, well...
Where most people are not out anyway, are they?
Well, some people do have to go to work. They take the buses and the public transportation and what have you. They're not out for recreational purposes. But what does that mean? The stores will be robbed, right? Instead of the adventitious robbery on the street. Cars will still be carjacked.
Yeah.
Gangs will still be engaged in drive-by shootings or other kinds of depredations. Those things won't stop. Drug trafficking won't stop. Human trafficking won't stop. It may not be seen on the street corners.
Is it worth doing?
Is what worth doing?
Bringing in the National Guard in Chicago.
Well, the whole premise of the statute that I quoted was that some people are being denied the
Right.
protection
I mean,
they're entitled
on
to
their
have.
behalf, I agree. But I'm just saying, do you
Isn't
think...
that what government is
Yeah,
for?
but I'm more gearing toward, my real question is, will it make a dent? Will it make a dent enough? Because you're now talking a bigger area, right? Mm-hmm. Extremely severe crime, wide-scale crime. Will the National Guard, if there's enough of them, be able to make a dent enough in helping transform the city?
Well, I think they'll put a definite lid on criminality. You're talking about transforming the city?
Well, from high horrific crime to even medium or low.
Yes, I think that will happen. They'll suppress it.
That's my real question.
They'll suppress it. But the question then becomes, when they leave, will there be a recrudescence of it? Mm-hmm. It will bubble up from the, below the surface. A lot of that is cultural. A lot of that is political. Right? The mayor of Chicago seems to be someone who's willing to tolerate this kind of behavior. The governor of Illinois, well, I don't know whether he's willing to tolerate it, but he certainly isn't willing, apparently, to have Mr. Trump come in and help him. So that's not helpful from my point of view. And so if you have, and that was true of the previous governor. This isn't just the previous mayor of Chicago, going back a ways, right? Chicago has always been a city ridden with one form of crime or another, just gotten worse and worse as the so-called progressives, if you will, have become more ensconced in the government for whatever reason. I leave that, it's a psychological problem.
Okay, so is there anything else you want to say about this before we go to the next?
Well, I wish that President Trump didn't have to do this, number one. And number two, I would hope that his advisors would take a closer look at his statutory authority, because that's the thing that will be challenged, nitpicking or the statutory authority. And the statute that I quoted, Section 253 of Title 10, is important because it lays the ultimate responsibility on the state officials for not having done enough. And that's the key to the whole thing. Trump is not coming in simply because he wants to bring in the National Guard to embarrass Pritzker or to embarrass the mayor of Chicago. He's coming in because the people of Chicago, certain segments of them, are being denied fundamental protections because of the dereliction of these city and state officials. And that's the key, because when the courts look at something like this, the Supreme Court will say, well, what's the real problem here? Is Trump just doing this because he's, on a crusade of his own? No, it's this problem here. I would certainly be able to defend that statute much better than to defend the statute that the Trump administration has said it's relying on.
Are you ready to talk a little bit about guns, gun control?
Sure, why not?
Being able to defend oneself and what happened to Charlie Kirk.
Why not?
Well, first of all, we were speaking a little bit briefly about your experience and understanding of guns, not just gun control in terms of the constitutionality of guns and the constitutionality of self-defense. But you were talking, and I wanted to go back to what you were saying, that you know a lot about shooting, and you were talking about the distance of the bullets and the gun that possibly assassinated Charlie Kirk. Did you want to say anything about that, or? Well,
I don't think we know yet. They haven't apparently.
There's a lot of information flowing. Yeah. This is September 11th, so it's not even it's about 24 full hours now, but there's all kinds of pieces and dribbles coming out. I always say with these investigations, we need to be patient.
Well, I know.
Sit tight,
And we haven't seen the gun yet.
Well, they say they think they saw.
Well, they think.
Yeah.
Well,
they found a gun in the woods.
Yeah, found a gun in the woods. Well, that's like the gun they found in the building there, Oswald's the sniper's nest, right? The Carcano rifle that they found and showed. We've got the rifle here, right? All right. And it was actually probably not that gun at all. But leave that aside. I would want to see the gun. That's number one. And then, of course, the problem here is if they don't have the bullet.
They're looking for the bullet.
Well, let them try to find the bullet. Right? They have to link the bullet to the gun. You have to do forensic ballistics, interior ballistics, right? You look at the rifling on the bullet, and you compare it to the rifling in the barrel.
Couldn't you do partial forensics on the person who was just murdered? Their body, the forensics of their body. I understand he was wearing a what do you call it? A vest, a bulletproof vest.
Well, if he's wearing a bulletproof vest, he was shot in the neck, as I understand. The
Well,
bulletproof vest
someone
wasn't
said
there.
that it hit part of the vest and then ricocheted into the neck.
Well, it could be. So I don't know. If they have the bullet, that's one thing.
They don't. They say they're looking for it.
Okay. If they have fragments of the bullet, it would depend on how big the fragments were, where they showed the rifling. What they can do with fragments of the bullet is they can do, it used to be neutron defection analysis. They can do chemical analysis and physical analysis of the pieces of the bullet and trace that to other bullets. So let's say this, they find the shooter, and there's a box of ammunition. And they've been able to do the appropriate chemical analysis on the fragments of the bullet that they found in Mr. Kirk. Then they do analysis of the bullets in the box of ammunition, and it turns out the analysis is exactly the same. They could probably argue, I think they would argue, that this bullet, the assassin's bullet, came from that box of ammunition. And that would be a reasonable presumption. Right? Now, maybe there are a dozen other boxes or 100 other boxes produced by that ammunition company. They're somewhere else. But we found this box of ammunition with this fellow we can trace him to the scene. Here's the gun. We don't have the gun, right? Oh, we have the gun, but we can't do the ballistics on it because we don't have enough of the bullet. But we can trace the bullet to the box of ammunition. And maybe if he didn't clean the gun, we can find some traces of the bullet in the barrel because the rifling will take a certain amount of material off of the bullet, perhaps. And that would be enough. They've done that in the past using analysis of the bullet and comparing it to the bullet that other bullets other cartridges this fellow has. So that's a possibility. But I'd still want to see the gun. Number one, what kind of a gun was this?
He had a canopy over his head. I mean, he was sitting under a canopy in a small chair, right, with people on his right and I think on his left too, or at least on his right, as we, So there was security behind him or around him. Some people online were showing hand signals that the security was giving like seconds before he was shot. And were worried about it. And there was some guy online who called everybody morons for thinking that the security would stand there knowing that he's going to be shot and be near him. I don't know. It's people were upset and they're looking and they're reading and they're going through. It's very traumatizing. I mean, we're doing this on September 11th.
Sure, absolutely. Especially given who or what he was. His position as what do they call, influencer.
He was a major leader in the Republican.
Yeah, he was no obscure figure.
Yeah, he was leading a movement of young people.
Yeah, and I don't know. I guess that's the motivation for someone to shoot him. But whoever shot him from 200 yards away, a downhill shot, was no amateur.
That's what I think.
He hadn't bought the gun. This wasn't his first rifle and his first shot.
It was one shot. Boom.
Yeah, well, he was someone that, in a sense, knew his business. Now, I'm not saying he was a professional assassin, right? What I'm saying was he knew how to handle a rifle. That's a fairly long-distance shot, especially given how small the target is at that distance. The human torso, right?
Yeah, he was. He had been getting a lot of death threats, and had some security concerns. There was security there. But the buildings, obviously there was no security around any of the buildings.
Yeah, well, once again, what is the sniper's nest? Right? It's a book depository, the fourth floor of the book depository. It's high up. The snipers are not shooting from, ground level typically. They want a complete open vista in front of them. So they're going to be getting to whatever is the appropriate height and distance. Where did the fellow shoot? Actually did shoot Trump at that.
Well, at least one of them did.
Well, the one did, not the one at the golf course.
No, I mean there were more. Apparently, some people believe there were more than one.
The boy that was shot.
No, yeah,
okay, the boy that was shot. Where was he? He was on a roof.
Yeah.
With a good vista, good view. Right? Somebody
some people say there were more than one shooter.
Well, whatever.
Yeah,
I'm just talking about him.
Was.
Just looking at that as a situation, right? Whoever put him there, whether he put himself there or somebody else, knew his business as a sniper. That's what you wanted to be. High enough up. He didn't have too much elevation. Right? Had a good view, and apparently enough of a knowledge of how to use a rifle, because he came pretty close.
This young man was 31 years old. Charlie Kirk was 31 years old.
Yeah.
He was a young guy.
Yeah. Well, he was outspoken. And in a way, apparently, that they couldn't silence him otherwise. I never followed him in particular, but I saw a few of his videos where he took on debates with these college students, and he ran circles around them.
Oh, yeah. He was eloquent. He was a very good speaker. He was knowledgeable about history, very religious. But he always invited conversation and talks and debates. He didn't insult people or yell at them.
That's right. He was challenging ideas and misconceptions, if you will, right? And he was very effective at it.
Do you think that the FBI will find who did it?
Probably in the same way they'll find who shot Kennedy. Either one of them, John or Robert. In the same way that they'll find the real killers in the O.J. Simpson case.
In the same way that the public will hear the truth about what happened on 9/11.
Yeah, the same way. The same way. Because there's probably more to this story than some simply deranged individual that decided to shoot.
It's too methodical.
Yeah. Now, deranged individuals sometimes are methodical. That's one aspect of that.
Well, I mean,
of the personality
it seems
sometimes.
more planned. The person just could disappear like that.
Yeah. Someone had scouted
Someone had seen somebody on the roof.
He knew where the security cameras were, so he wouldn't be necessarily photographed coming or going. All right, that's obvious too. Otherwise, they'd have that security video, and we'd be seeing it already with pictures of the man, right? Because we want to apprehend him.
They have some pictures on the internet running around.
Well, but he wasn't looking up at it, in that type of situation.
They're very close to NSA, right? And just on a geolocation level, there's satellites all over the place. Are you telling me that we can't know who did it just from the tech that's available to these agencies?
Well, there are still people that believe Lee Harvey Oswald acted alone. Right? They still sold that story. Right? I don't know what his involvement was in that. This is the point I always make. He was clearly involved with the FBI. He was clearly involved with the CIA.
Right.
Okay? He was clearly involved with machinations going on with the anti-Cubans and the pro-Castroites. Right? There was a whole melange of governmental intelligence agency involvements, including naval intelligence, with Lee Harvey Oswald. But he was not acting alone. That's the one thing I know. Lee Harvey Oswald was not acting alone. And it's the people with whom he was acting that we really want. And we never found out about them. And that's gone. It's washed down the river of history. They've sanitized the files. People have died.
Right.
It's all gone. We'll never find out.
So right now, one side of the aisle is already talking about gun control as the reason to prevent, is the way to prevent this in the future. But even if that were to happen, it's not going to stop someone who's a sharpshooter, who's highly trained and skilled from doing what they do.
Well, it's not going to stop the professional assassin.
Right.
Is it going to stop the adventitious assassin? The person who gets an idea, deranged individual gets an idea. Well, I guess only if there were no guns available anywhere. I mean, unless you have a record, psychiatric record, it's already in the data processing system. You go into a gun store and you check off on the federal firearms form that you're not disqualified. Check. And then they put that through the background check system. If you're not already in the background system because you've had psychiatric evaluation or something that has caused you to be, come under scrutiny of the appropriate authorities, you buy the gun. So what are they going to do, outlaw all gun sales? And what kind of a gun do you need for that kind of an assassination? You're probably not going to use a semi-automatic rifle of any kind. You're going to use a very accurate bolt-action rifle, the so-called hunting rifle or target rifle, right? How many thousands of those are available and can actually be bought through private sales? You never even come across a dealer, a federal firearms dealer. And what do you need to do to learn how to use one of those? Go to one of thousands of gun ranges in the country, box of ammunition, your telescopic sight. I could teach someone to do that in a couple of sessions who had never shot a gun before. As an instructor, I'm not suggesting I'm going to suggest that they're going to use it for improper purposes. But if you're talking about what does it take to become a reasonably good marksman with a reasonably accurate rifle, it's not years worth of training.
No?
No, I don't think so. Now, this fellow, or man or woman, whatever he was, shooting downhill, 200 yards away, at a relatively small target under a canopy, he probably had some experience. This wasn't the first time. This wasn't the guy that goes out hunting deer for the first time with his newly acquired Christmas present. He knew what he was doing. But we'll find out. He certainly wasn't using an Italian Carcano rifle, if you know what I mean.
I don't.
That was the one Lee Harvey Oswald supposedly used. The World War II surplus that he bought from Klein's Sporting Goods in Chicago by mail, when you could still buy guns by mail. But you know what the consequence of that was? That was the Gun Control Act that followed later to stop mail-order sales. So they did use that, the people who wanted gun control, they did use the fact that Oswald had purchased this gun mail order and it was delivered to him through the post office.
Do we know that as a fact or a narrative?
Well, we know that as a fact because they have the records from Klein Sporting Goods, and it went to somebody named A. Hidell, which was an alias that apparently Oswald was using, to a post office box that he had opened up. So what's that connection to him? Now, how that was arranged and what kind of a scheme that was a part of, God knows. All right. All I'm saying is that the narrative that was given was this assassin had obtained this surplus gun from mail order from this Chicago dealer. And so in the next round of gun control, they eliminated that. And you couldn't buy a gun without going through a federal firearms licensee. That was 1968 Gun Control Act. You couldn't just order a gun from Chicago and have the gun delivered to you in the mail. You had to go through a federal firearms licensee. And as a result of that, there was some kind of check that went along. Did you have a driver's license? And so, the minimum at the time. But then that expanded into the background check system that we have now. And they could expand that even further, God knows.
Do you ever wonder if people like Robert F. Kennedy, RJK, Tulsi Gabbard, at the end of this administration, if it doesn't renew itself, could be in serious danger? The work they're doing, very different work, but very serious work, they could have their security removed from the next administration, whoever that is, possibly.
Well, of course, the question would be, what would the incentive be to assassinate them or try to harm them after they were out of power?
Retribution.
Well, maybe. I don't know what has Tulsi Gabbard, for instance, done that would justify retribution.
Have you been reading lately? I mean, she's exposing all this material about former president of the United States, Barack Obama.
Yeah, well, maybe it's going to come to nothing. A lot of people have been exposing things of Barack Obama since the birth certificate conflict, right?
That's
true.
And
it came to nothing. He was elected twice, supposedly. All right. Now, Robert Kennedy's another story because Robert Kennedy has made and will be making many, many enemies in the pharmaceutical
It's already
area.
happening.
Well, I've said that's right. It's already there, and he'll be making more. That would be my anticipation. The longer he stays in office, the more trouble he's going to cause for those people. And, I can understand retribution coming from that direction.
So, do you feel that the United States will continue to honor the Second Amendment of allowing people, of empowering people to defend themselves if necessary.
Why do you think they were honoring it now? I mean, you said continue to honor.
Well,
why would
it's mixed.
Why would anyone who looked at the present situation say that they're honoring it now?
Give me an example.
Well, I'll give you the biggest example because we talked about this earlier. The complete disorganization of the militia of the several states. Second Amendment begins, a well-regulated militia being necessary to the security of a free state. Those are the first 13 words. Then it's the right of the people to keep and bear arms shall not be infringed. That's the following 14. Why is the right of people to keep and bear arms not to be infringed? So that the people can perform their militia function, which is necessary to the security of a free state, so that we will have an armed citizenry. And armed in what manner? Armed in a manner to perform that militia function. And that is a military, quasi-military, quasi-police function. It was all decided by the Supreme Court in the case versus United States versus Miller, where they defined the parameters of Second Amendment in terms of what would advance a well-regulated militia, what would serve the common defense, what would be part of the normal operating equipment of such people. Well, what would that be? Typically today, a militiaman or a militia woman, what kind of armament would they have? And I'm talking about arms, firearms. Well, they would have at least semi-automatic rifles because the militia is primarily made up of infantry. There'd be other people in the militia, specialized groups, but the militia was always made up of infantry people. So they'd be armed with rifles and handguns. What kind of rifles would they have? Semi-automatic rifles, at least, minimum, right, as opposed to automatic rifles. And the difference is semi-automatic rifle fires, each pull of the trigger goes bang, but then the trigger is released and then it goes bang and bang until it runs out of ammunition. Automatic rifle, you pull the trigger once and it goes bang, 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 bang until it runs out of ammunition. That's the difference. The Army people have automatic weapons or sometimes burst fire weapons. They're set to fire 2 or 3 shots, bang, 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 and then you have to pull the trigger again. Very wasteful. As a firearms instructor, I'll tell you, that's a very wasteful situation. All right? But they have those. The militiamen would be perfectly satisfactorily armed with semi-automatic rifles.
But do you feel or think that the citizenry needs to have a semi-automatic gun?
They need to be, the constitutional requirement is to have these things called the militia of the several states. The militia of the several states are made up of people who can perform certain functions. Those functions, one of them being repel invasions. Let's just start with that one. Repel invasion. How do you repel an invasion with a single-shot shotgun? To use Joe Biden's argument, all you need is a shotgun. Well, even the Chinese Women's Army is not going to be repelled with people with single-shot shotguns.
You
right?
use that example a lot. You must like it.
Well, they have a first-class army. If you've ever seen them marching.
I haven't.
Look it up.
Right.
Chinese Women's Army marching in the Chinese Military Day parades, and you'll see how highly disciplined they look, all right? And I imagine they can shoot those guns that they have. So if you just look at the first responsibility of the militia, repel invasions, you would say, well, they need the type of weapons that would be in the hands of enemy forces who were invading the country. What would the enemy infantry have? That's what our militia should have. Who are the militia? Well, let's take Virginia. Virginia's definition of a well-regulated militia composed of the body of the people trained to arms.
Oh, my God, I'm looking at them right now while you're talking.
All right, there they are.
Holy Toledo.
Yeah, they look pretty sharp, all right?
Yeah.
Yeah, they're first class.
They're dressed up nice, too. They look like they could do anything.
It's very spiffy outfits, but
Yes.
watch the way they march.
There's a serious
Absolute
action.
precision, all
Holy
right?
Toledo.
Holy Toledo is the word for it, okay? A well-regulated militia being necessary to secure a free state. But the Virginia Constitution says a well-regulated militia being composed of the body of the people trained to arms. What is the body of the people? It's the great mass of people.
Yes.
Okay, what is trained to arms? Trained
ability
to the
to fight.
use of firearms that would perform the militia function, security of a free state. What would that be? I'm just going through it. What would that be? At a minimum, it would be the semi-automatic rifle. And what are those that are most common in the United States today? It's the so-called AR-15 pattern, which is similar to the guns that the Army and the Marines have, all right? And these are all, in most cases, purchasable. Congress hasn't outlawed them. Some states limit them or outlaw them. Maryland, New Jersey. I mean, you go out Massachusetts, you can't buy one of these. Or you can only buy them under onerous conditions, registering them or something. Is that consistent with the concept of an armed population? Of course not. Let's take Virginia, for instance. Virginia, the governor can call out the unorganized militia, that's the average citizenry, in case of invasion of the state. He also has the power, when he calls people out, to have them bring their own equipment and to train them and to cause them to be armed. So I guess he could say, we're being invaded by the Chinese Women's Army, and I'm calling up 10,000 members of the unorganized militia. Please bring your guns with you, because we have no Virginia arsenal to provide you with guns. What would happen?
That's bad news.
Yeah. All right? Now, some people would have guns. I know people who would have guns and would have some ammunition available. They could show up with that. But among these 10,000, there might be 2,000 or 3,000 who say, well, I never bought a gun of this kind. I don't even know how to shoot it. Wait a minute. What about your militia duty? You're subject to being called up for this purpose, and you're not armed, you're not trained, you're not ready to perform that function? One would have to say, well, who's derelict here? Virginia legislature, number one, because they haven't fleshed out this statute. Virginia governor, number two, because he's a he now, he hasn't come up with appropriate executive orders to cause people to be armed, if only simply to encourage them. And let's take someone running for governor in Virginia who has a record of being in favor of gun control, who wants to outlaw the very kinds of guns that the unorganized militia would have to perform the duty which the Virginia governor could impose on them by calling them forth.
So basically, outlawing guns is unconstitutional by its very nature. Am I correct or incorrect from what you're saying?
Well, outlawing such guns as could be used for militia functions is unconstitutional.
Okay, that's what I wanted.
And it is a dereliction of duty on behalf of any governor who does this when he's governor. And I would say it's a disqualification for anyone who's running for governor to say that that person is running on a platform that these types of guns are going to be outlawed. There's going to be increased gun control in Virginia or anywhere else. Because as soon as that person says that, you're saying, well, you're going to be in violation of your responsibilities as a governor. You're telling us right now that you're going to make it impossible to call out the unorganized militia, properly armed, to perform these functions which they might be required to do. How can you possibly square that with your duty as a governor? And if you can't square that as your duty as a governor, then you are absolutely disqualified even to hold yourself up as a candidate to be a governor.
We're living in a time capsule. We're back to that time capsule concept. Possibly.
Well, possibly. All right.
If this has to be upheld.
Well, it's been upheld to a certain extent. You had the case that I originally mentioned to you, United States versus Miller, in which the Supreme Court laid out these, I would call them standards, for a firearm to be protected by the Second Amendment. It was useful for a well-regulated militia. It was something that was a militia-type firearm. It was part of the armament of the regular forces, or it could be used for the common defense. Well, I would say that almost anything in the panoply of modern firearms would fit those categories. In fact, you can go back to firearms at the turn of the 20th century. Firearms that developed in the late 1800s and the early 1900s, which would still be effective firearms for those purposes today. All of the bolt-action military rifles. There were semi-automatic rifles at that period of time. Just take the model 1911 United States Colt pistol, Army pistol. Are people still using that today for self-defense purposes? Of course they are. They're probably more popular today than they were then in terms of the average person using them. You're talking about firearms that are 100 years old, or types of firearms that are 100 years old. Let's not even talk about the AR-15. AR-15s came out, in the 1960s? So they're 80 years old. Right? So if you wanted to fit the definition in the United States versus Miller case, you could probably lump all the firearms that you could find in any gun shop today and say every one of these is protected, plus a lot of them that are probably not normally in the hands of the average person, but maybe should be. And then on the other hand, you have what I would call these are, in a sense, it's a dereliction on behalf of the Supreme Court. There's the Heller case, the McDonald case, Chicago. The Heller case was D.C., the McDonald case was City of Chicago, the Bruin case, which was New York cases. And they all focus on the individual right to protect oneself with a firearm. That is really not what the Second Amendment is about. It's not there to protect the individual right. It's there to protect the polity, the social structure, the political structure against the dangers. It's there to provide the security of a free state.
See, that's the key right there.
Security of a free state. And in providing the security of a free state, as a member of the militia, what may happen to you? You may lose your life. You may be seriously wounded and maimed. You may be driven insane, what's called post-traumatic stress disorder, right? All sorts of things may happen to you because the very first duty you have is to repel invasions. The next one is to suppress insurrections. Well, insurrections can become pretty violent. And the third one, executing the laws. Well, how many police are killed or injured in executing the laws in the normal course of their duties? A significant number, right? So the Second Amendment is not looking really to protect your life at all. It's putting you in a position where you may lose your life or be subject to terrific trauma. Now, it just so happens.
So it's really there to secure a free state.
Period. It's to secure a free state.
Period.
Okay, it's this higher level responsibility. But it just so happens that if you have a gun and you know how to use it, you can defend yourself with that firearm. You can engage in self-defense with a firearm. Right? So everyone who was a militia member and had one or more guns and was trained in the use of those guns would be capable of defending himself and his family and others in terms of adventitious criminal activity. But it's not that ability to defend yourself against adventitious criminal activity that the Second Amendment is focusing on. As I like to put it, to be somewhat crude, the Second Amendment is not about defending your miserable life. It's defending our political structure, our state, and not just our state in general, but the security of a particular kind of state, a free state. Because a free state is one in which the people actually have control. And how do the people actually have control unless they are the ultimate source of force? You know, Mao Zedong put it very, cleverly, but truthfully. Political power goes out of the barrel of a gun. If the police have the ultimate force, we have a police state. If the people have the ultimate force, it's a free state. That's the difference. Very simple. And that's what the Second Amendment is designed to protect. Now, unfortunately, in these three cases that have been decided, Heller and McDonald and Bruin, the Supreme Court, for whatever reason, focused on the individual right to keep and bear arms by disregarding the first 13 words of the Second Amendment. Now, no student in middle school...
Is that what your book is about?
Yeah,
the first
it's
13
the disregard
words?
of the first 13, the importance of the first 13 words on the other side. But if you're a student in middle school and you're taking English grammar or English composition, and you told the teacher, well, I can simply disregard half of this sentence, the teacher would come back to you and say, well, that's not the way to read an English sentence. The author put in all of those words to express a particular line of thought. And you, as the student, as the reader, have to figure out what he meant by using all of the words, not just part of them. And the peculiar thing about law is, of course, that that's a legal precept. You can't simply, on the Constitution, say, well, I'm not going to pay attention to these words or this phrase, or I'm not going to pay attention to that part of the Constitution because I think some other part of the Constitution is more important. You have to integrate it all. And in the Second Amendment, obviously, it's an integrated whole as well. And I'll go one step beyond that. The Bill of Rights was put in as the preamble says. Most people don't realize when the Bill of Rights was submitted to the states, there was a preamble to it. in which Congress explained what it was doing. And it said, we're putting this to the states for ratification to prevent misconstruction or abuse of the powers that are already in the Constitution. It was not to overturn abusive powers that are already there. All right? There was not a right in the Constitution in Congress to deny people possession of firearms, and therefore we needed a Second Amendment to overturn that power. It was to prevent misconstruction or abuse. So what is misconstruction? It's a mistake. They read their powers in an erroneous fashion. Second Amendment tells them, oh no, you have to read your powers with respect to this precept that we're putting in front of you. What is abuse? Abuse is intentionally to misconstrue, intentionally to read those powers incorrectly. So the first thing we would do in reading the Bill of Rights is we would say, well, where does this admonition, the Second Amendment, where does it find an echo in the Constitution? Where is there something in the Constitution that might refer to arms, militia? And it's right there. There are the two powers of Congress, to arm the militia, to call forth the militia, among other things. And there's the authority of the president to be commander-in-chief of these things called the militia of the several states. So you immediately say, well, the Second Amendment is there to make sure that Congress properly arms the militia so they can be called forth for these circumstances, and so that the president can effectively act as the commander-in-chief when the militia are in the active service of the United States, and also to make sure that the states don't in some way eliminate their militia, that is, simply remove it from the state codes or make the members of the militia ineffective, because the president is the commander and this chief of this thing called the militia of the several states, which means they can't be removed by the states, and Congress has the authority to do these things with respect to the militia, which means that the militia can't, in the states, that the states can't, how should I say, disarm in a general sense the militia. There's an interesting case in respect of this. Presser versus Illinois, back in the 1880s, in which the Supreme Court makes a kind of a by-the-way statement. It says, irrespective of the Second Amendment, the states cannot disarm their population, because to do so would be to prevent the militia of the states from performing their functions to the national government. So the state militias are not simply state institutions, but they have this complex obligation to the government in Washington, D.C., both the Congress and to the president. So if we look at gun control in the states, Maryland, Massachusetts, Illinois, California, we say, well, this effectively disarms large segments of their population.
Yeah, it does.
Large, in the states.
Yeah.
So they can't perform, the state governments are preventing the state's militia, members of the militia, potentially from performing their duty to the national government. Because if Congress called out the militia of Virginia, the unorganized militia, Congress would discover they're unarmed.
Do you actually believe or accept for 1 second that the Congress today would call out the militia? Or even knows that that's something that's important to do?
Well, there's a statute there.
Yeah, but
I'm not responsible for their derelictions of duty. Yeah, you're telling me we have a lot of people in Congress who don't understand the Constitution.
Never read it.
Who probably don't understand that a lot of these laws exist.
Right.
Same is true in the executive branch, because we've already discussed about what laws the president should be using, as opposed to what his people are saying he's using, demonstrates that they haven't thought that through. Right? What am I supposed to do about that? Am I responsible for their derelictions of duty, for their incompetence, for their ignorance, for their arrogance? No. I'm pointing this out because I would hope to educate the people of this country to change the composition of Congress and the executive department, and maybe the judiciary as well, to correct these problems. So I'm just looking at the statutes of some of these states, Maryland, Massachusetts, Illinois, California. They're obvious.
Here's my question. Are you saying, by what you said, that, like, let's say California, a California resident cannot buy a gun?
Well, certain types of guns, and they have certain restrictions. Let's take Maryland.
Can California restrict the type of guns somebody...
They do.
Okay.
Isn't that unconstitutional? Onerous restrictions. They have but let's just take Maryland, because Maryland has gone through this cycle twice.
Okay.
All right? It had one Gun Control Act, and that went up all the way to the Fourth Circuit Court of Appeals and was sustained. And then they amended that, changed that, and that case went all the way up to the Court of Appeals, Fourth Circuit, and that was sustained as well. In both cases, the Supreme Court refused to hear it. Petition for certiorari. They refused to take it, all right? Although those opinions were in direct contradiction of the Supreme Court's opinion in the District of Columbia versus Heller, for instance, all right? Now, what did that do? It outlawed further purchase, transfer, probably gifts as well, of certain kinds of firearms, the so-called assault rifles, AR-15 types, all right? Now, I think even under the second statute, if you already possessed one, it was grandfathered in by the statute, you could keep it. But you couldn't sell it to somebody else unless it was a federal firearms dealer who would then, take it out of the state, because they couldn't sell it in the state. So if you were a member of the Maryland militia, which was probably everyone from 16 to 40-something, probably similar. I didn't look at the actual dates. But you didn't have one of those guns. You couldn't get one.
I mean, this is kind of, with what you're sharing, it's kind of insane because the public cannot defend the state that they're in based on this militia authorities and capabilities. It seems like it's been wiped out.
Yeah, well, it is cognitive dissonance, isn't it?
Yes.
Yeah. But it's the result of, how shall I put it? There is always a desire on the part of people who want to tyrannize over others through government to make sure that those others cannot resist them. And ultimately, what do?
You disarm them.
You disarm them. Because even in the police state, in theory, if you have weapons in the hands of the general population, at some point there will be resistance. This was Solzhenitsyn's point. He said they knew that the secret police were coming into the apartment buildings, and everyone was quaking in their boots in their little apartment, wondering if the secret police were going to knock on their door and take them away. And they were thankful that the secret police knocked on somebody else's door. And he said, why didn't we have the courage when those people came in to meet them with whatever we had? A tire iron, a baseball, a bat, something. We didn't have guns because we'd been disarmed. If we had had the courage to do that, we might have stopped them because there were far more of us than there were of them. And that would be even more true in an armed population. So what's the recourse for the tyrant? Disarm the population.
And that's what's happened in the UK.
And that's what they're doing. They're doing this in direct violation of this concept that the population must be armed in order to perform this constitutional function. It has nothing, and they say this all the time, well, you don't need an AR-15 to defend yourself at home. Maybe you do, maybe you don't. Maybe it's an armed invasion by 6 thugs, all of them being armed. And maybe you need an AR-15. Maybe it's one person. We don't know. But that's not the consequential question. The consequential question is not what you need to defend your home or yourself, but what you need as a member of the militia to defend your state.
That entire paradigm and concept is totally missing from our population.
That's
totally
right.
And completely.
That's right. And where did that start? It started in 1903 with the creation of this dichotomy between the organized militia, National Guard, and the unorganized militia, everyone else. The people that were in favor of that, and I think in the background, I'm not going to say the members of the National Guard, they wanted to be recognized. Okay, fine. They should have been recognized in some way within the correct militia structure. They were recognized in this kind of bastardized structure as the troops that the states could raise with the consent of Congress. Everyone else is put into the unorganized militia. Why? I think because the people behind the scenes realized we don't want the vast mass of people organized, armed, and trained because they pose a danger to us.
So in effect, the direct pathway to tyranny anywhere is to disarm the population, period.
Yeah. Well, disarm and disorganize.
Right.
Because you could have everybody armed, But number one, they might not know what to do in an organized fashion.
Well, that's pretty prevalent.
They wouldn't have a chain of command. They wouldn't recognize that they had ultimate legal authority. Right? The militia is not some kind of group of disorganized people running around the woods with guns. It's supposed to be a highly organized, structured, trained, and armed institution of each state, and possibly an institution of the government of the United States, if called forth, that will perform certain kinds of functions: repel invasions, suppress insurrections, execute laws. Well, to do those three things, any one of them or all three of them, you have to have training.
But what if people say, by having, let's take a scenario, the population's all armed. Let's say we're in the United States, everybody's armed. And we have an obvious invasion of 20 to 30 million people being let into the country who have no ID. We don't know who they are. We don't know where they came from. They don't know, you know what I'm saying? We don't know. What if, I'm just bringing this up for you to respond to it. What if people started to take the AR-15s and start gunning down these immigrants?
Well, my point is that when you're in the militia, you're properly disciplined.
But who trains you? It's not the National Guard that trains you, is
Well,
it?
it's the militia that trains you. This is an institutional structure. Who trains you in the police?
Well, let's say I want to go today.
You go to a police academy.
Where is my militia training?
It's not there. Now, don't lay that bad trip on me.
Where am I going?
I'm not responsible for that. There should be a militia office within the government of the state, subject directly to the governor, which would have a training facility, which would have an arming facility.
Who pays for this?
The taxpayers, like anybody else.
Where does the money come from?
It comes from the militiamen.
No, what I'm saying...
It comes. Remember how this happened originally. A statute was passed, and you can find dozens of these statutes throughout colonial period. And here's how they worked. They required, not you, because women weren't included, men. They required men from 15 or 16 years of age, whatever. When you reached that age, or if you came into the state, became a new resident, you had a certain length of time, 30 days perhaps, in which to acquire a set of equipment, rifle or carbine, cartridge belt, so many cartridges, so much ammunition, powder, and shot. If you were in the cavalry, you had to have a horse, you had to have etc. Right? Maybe 2 pistols, there's a whole list of things. And then you had to come out for regular training. And if you didn't have your equipment, you were fined. If you didn't come out for the regular training, you were fined. If you didn't show up when an alarm was called, that is to serve in the field, you were subject to court-martial, right? So who provided this equipment for you? You did. This was a kind of tax on you as being a member of the militia. Who provided the training? Well, you did. You came out for a certain amount of time. That was a tax on you in terms of your time, right? So you provided all of this. Now, for the poor, typically someone would provide that, someone else. You're too poor to get a gun. Fine. The militia might provide it because the militia was mulcting fines on its members who didn't have the right equipment. They'd fine them so much for it. And so the militia had money. They'd buy a gun for this poor person. It wasn't his gun in the sense of his personal property. He had it as long as he was in the militia. Or the town would do it. In Rhode Island, that had town government. The town would do it. Where they had county government, the county government might do it. So in Virginia, a poor person in the county would get a gun provided to him by the county, and he would keep this as his personal militia firearm as long as he was in the county. When he left, he had to turn it back over to the militia to give to somebody else. All right? So the burden of this
is on the individual.
Was on the individual.
Right.
Why? Because you have a duty. The fundamental concept was, as a member of the polity, as a member of the political structure, you have a duty to in some way ensure the security and defense of that society. Now, what if you were a woman, as an example, and you were a widow, and you had a son who now became 16 years of age in Virginia, and he now had an obligation to buy a gun. He didn't have any money. He's living at home with you. Maybe it's a farm. You had the financial obligation to provide him with a gun. What if you were a male and you had servants, apprentices, they were probably not receiving any money at all. They were getting room and board, and you were teaching them a trade. You had to provide their gun. Right? So this obligation went beyond the individual sometimes. It went to the family.
Is this written?
Excuse me?
Is this written?
Yeah, sure. Of course it's written.
Where is it?
It's in the statute books, the Virginia statute books. There's a collection called Henning's. Henning's statute books covers the entire colonial period. Read it. Just go to the table of contents, look up militia, and they'll tell you the statutes.
Is Virginia a rare example of this?
No, they're all the same.
Is it a blueprint?
They're all the same. They're all the same. I read every colonial statute in all the 13 colonies. They're all the same.
Wow.
In structure, they may have particular differences, but in structure, they're all the same. Why? Because they were operating under the same legal system. These were all British colonies. They weren't really separate entities. Right? So you'll find, and the British system, if you go back far enough, you'll find the same type of system, militia structure, right? But it became fundamentally important in the colonies because what happened when the first colonies showed up? They were facing potentially hostile Indians. They were facing potentially inroads by the French, or in the South, the Spanish. So even the colonial charters, in which the king is giving land to his cronies. He sends them over there with this charter, and one of the duties that was always there imposed on his cronies, I would put it, the people who received this charter, was you're supposed to raise up and train the people in your colony to be able to defend this colony against the king's enemies. So it's right there at the beginning. You're given this power, you're given this authority, you're given this wealth, really, because you could exploit this territory, but you have this obligation to raise a force to defend this territory in the king's name because the king is giving you this charter. So it started right from the very beginning. And then as various statutes were passed, as they developed legislatures, they began passing what they call ordinances or acts. They give them different names. They structure them in a certain fashion, and that fashion is followed, maybe expanded, all the way up to the period of the War of Independence. These things were in existence in every one of the colonies during the War of Independence, every one of the independent states, and they put them in the Constitution right there. And then to make it absolutely clear, they put it in the Second Amendment and start off a well-regulated militia being necessary to secure the free state. Not an individual right to defend himself being necessary. Doesn't say anything about an individual right.
But that doesn't mean you don't have an individual right.
No, you would have an individual right. If the Second Amendment weren't even there, you would have an individual right of self-defense. English common law, Blackstone, who was the great expositor of English common law, he wrote a book called The Commentaries on the Laws of England. More copies of that book sold in America than sold in England. It was the Bible of the legal profession, as it were. And he makes this comment about self-defense. He says self-defense is the primordial rule of the law of nature, and it cannot be taken away by any law of society. All right? So it's always there. It had nothing to do with the Second Amendment in principle.
Done in the
it's
UK.
always there. Now, if you have a gun because you're required to have a gun, which is the best situation of all, then obviously you can use that gun to defend yourself, right? Just as you could use a baseball bat or whatever, any other implement, sword, knife, you have a gun. So if you're looking at it from that point of view, you'd say, well, obviously the individual right to defend himself with a gun is a combination of these two. The natural right to defend yourself, which no government can take away, and this constitutional right to have a gun as part of your duty to perform militia functions. And so when you think of a person, let's say a person is out on the street carrying a concealed firearm, which you can do in Virginia, and he's accosted, and his life is threatened by someone with a knife, and he defends himself with the gun. What is he doing besides defending himself? Well, he is executing the law against that individual. Why? Because there is no judge, there is no jury, there is no policeman there to intercede on his behalf. This fellow is violating his rights in a violent way, and we could probably assign all sorts of statutory infractions. There's no one there to intercede on behalf of the legal system. So the person defending himself becomes the executor of the law. That's the exact concept. If you read Blackstone, that's what Blackstone says. It says the reason that the law of nature recognizes this is because there is no other law present at the time when these things happen. And the law has to be executed. The law has to be enforced by the person who is being attacked. Well, what's the third in that threefold list of the powers of and duties of the militia? What's the third one? First one is repel invasions. Second one is suppress insurrections. Third one is execute the law. So that militiaman standing there who's now attacked, who shoots the assailant, is executing the law. He's performing a militia function. It may be a unique militia function involving just him and this other person, but it's a militia function. He's executing the law because of what? No one else can.
Fascinating.
All right?
Fascinating. This whole gestalt, everything you're talking about, is missing in the consciousness and the awareness of the American people at large.
Intentionally so. Not on behalf of the average American. In a sense, it is in the average American. He doesn't take any care to familiarize himself with the Constitution.
Do you think that the Constitution has been changed, altered, or interfered with in the writing of it? You know how books have been changed and taken off the market and then re-released, etc. What do you think
No,
about...
because I've seen facsimiles of the original Constitution, and the words are exactly the same.
Okay, great.
It has been changed in terms of adding amendments. All right, there have been amendments of the Bill of Rights as an example. All right, there have been additions to the Constitution in terms of the amendments, and we know what they are.
So where can people get a copy of the Constitution? Can you recommend where they can buy it?
Go to the internet and print it off. You can find 100 sites that will give you a Constitution PDF or whatever that you can immediately print. I mean, you can go, if you want to, you can go to the United States Printing Office, and they have this little book called The Constitution of the United States as Amended with Analytical Index. And they print these, I don't know, every year. I happen to have one that's the 1976 printing because that was obviously the anniversary, right? Kind of an anniversary printing of the Constitution. And this is a very nice one because it lays it all out. And then it has an index, so if you want to find a word and phrase in the Constitution, you can immediately jump to the actual provision of the Constitution. And this one also has some of the amendments which were not ratified, which were proposed to the states, but which weren't ratified, which are interesting historically.
How old is the one that you're using?
Well, this one happens to be the bicentennial edition, 1976. But if you go to the United States Government Printing Office online, I'm sure they're still producing these things.
Okay.
Maybe not the bicentennial
Yours
edition.
Yours is like a
the
little yellowish booklet.
Yeah, it's a booklet. It's very nice because it has the
Is it the keepsake edition?
Well, this is the bicentennial edition. I'm sure this isn't available anymore.
I see one on Amazon. Constitution of the United States of America Bicentennial Keepsake Edition.
Well, there you go. So I guess you can still buy it.
Okay.
All right.
Wonderful.
I like it because it has these additional study aids in it.
All right. Now, you can be found at newswithviews.com as the writer, one of the writers.
That's right.
And I'd like to invite you back to address a totally different subject. I want to talk about the federal, unless you want to tackle some of this now with the Federal Reserve. Okay. Let's give the audience two little tidbits about the Federal Reserve.
Or I'll give one tidbit, historical tidbit about the Federal Reserve. And what you have to understand is the structure of the Federal Reserve. It is a bank cartel. At the head of this operation is a thing called the Board of Governors. And they are people who are appointed by the President and confirmed by the Senate. And then immediately below the Board of Governors is the Federal Open Market Committee, which contains some of the Board of Governors, and some of the presidents of the Federal Reserve regional banks. And there are 12 Federal Reserve regional banks, and these are private banks. There's one in New York, there's one in St. Louis, there's one in Richmond, there's one in San Francisco. I go on, but there are 12 of them scattered around the country. And the reason for creating these 12 was economic conditions are different in different parts of the country, and so we want banks that will be responding to and know about these differences. And then below the 12 regional banks, there are hundreds of so-called member banks. And these are like the commercial banks, Citibank, Wells Fargo, whatever, some of the state banks. And they are banks that have joined the Federal Reserve by buying stock in the regional banks. So they have the right through their stock to elect the officers and directors of the regional banks, and then the presidents of the regional banks serve in the open market committee. And so there's a big cartel structure. And this was done in 1913. And in the debates in Congress, one fellow stood up in the House of Representatives and said, you know what we're doing here? He said, if we were to create this kind of a cartel structure for other industries, the railroads, for instance, everyone would recognize that this is unconstitutional. We can't be doing this as a generality, let alone for the banks. Well, they didn't pay any attention to him. And they passed the Federal Reserve Act in December of 1913. And its purpose was to prevent depressions and to prevent runaway inflations. And in fact, they argued that we now have a scientific method with the Federal Reserve for preventing these financial problems. Scientific management of money and credit. That's how they sold it. 20 years later, greatest depression the world had ever seen. All right? Okay. So much for scientific management. They actually had another depression in 1919, 1920, but that was a small one. Okay. Well, what happened in the 1930s was when Franklin Roosevelt came in, the Congress was desperate to raise prices, to get people employed again. And one of the things they did was to pass a bill called the National Industrial Recovery Act of 1933. And this created a cartel in every form of industry in the country. So there's a steel cartel, there was a coal cartel. And this was made up of the producers, the private producers. And above it was the National Recovery Administration, which was run by a man by the name of General Hugh Johnson. His name was Hugh Johnson. And this was the bureaucratic agency on the top. And then above that was Franklin D. Roosevelt himself, because the statute allowed in extraordinary circumstances for him to make decisions. So they created cartels all over American industry and business. And the theory was that these cartels would control output, and they would therefore control prices and wage rates and all these economic variables, and this would somehow cause prices to rise and prosperity to return. Now, what was recognized at the time was this was the American version of Mussolini's corporative state or fascist system. It was recognized at the time. Hugh Johnson said it. Francis Perkins, the Secretary of Labor, is on record as saying it, and a lot of other people said it. And at that time, Mussolini was not thought of as an opera buffa character.
What does that mean?
Comic opera. Right, some
okay.
You'd see in what do we call it now? Musical comedy, right? A fool in a musical comedy show. No, he was considered to be a real statesman. Now he made a mistake. He allied himself with Hitler and did a lot of other bad things. But at that time, in the early 30s, he was considered to be a statesman, and there were a lot of people, especially in Europe, that were looking at this corporative state structure that he had set up in Italy as a way to solve depressions and other economic problems in Europe. There were people in France. You had French corporativists. The Portuguese Salazar was a corporativist, the strong man in Portugal. Austrian corporativists. They had similar people arguing for this in England. It was all over the place. So they set this thing up under Roosevelt. And in New York, there was a live poultry code. These code authorities.
Actually, you shared about this, but I want you to finish.
I'm going to finish this.
I want you to share about this too.
Because this is important.
Again.
There was a live poultry code, which was the code authority for people dealing in chickens. And it had regulations that said that you had to sell, if you were a poultry dealer, you had to sell so many chickens in a coop. And you couldn't allow a customer to come and say, well, I don't want that chicken because I think that chicken might be sick. Give me another chicken, or I'll only buy the 2 chickens. You couldn't do that. There were strict regulations. Well, the Schechter brothers didn't abide by the regulations. And apparently they let customers not buy the sick chickens. That's why it was called the sick chicken case. And they were prosecuted because the penalties for violating the code were criminal in nature. They were prosecuted. Case went all the way to the Supreme Court of the United States. And the government argued it was Schechter Brothers versus ALA Schechter Poultry Company versus the United States. It goes all the way to the Supreme Court of the United States. And the government argued that, well, all we're doing here is giving power to these industrial groups that know what they're doing. We in government don't know how to regulate the steel industry or the coal industry or the poultry industry.
You're going to bring us back to what this has to do with the Fed.
Yeah, exactly. Okay. We're giving the power to the experts in the field, all right, the private parties. And the Supreme Court said that sort of delegation of governmental authority to private parties is, and I quote, unknown to our law, quote unquote. There was no way that they could figure out that this was constitutional. 9-0. The Federal Reserve is one of these code-type authorities. It is a cartel in which power over banking, money, and credit has been delegated by Congress to this banking cartel. And it has its own National Recovery Administration, the Board of Governors. And in fact, it claims independence.
Okay. So
how much have we heard? So if one were to say today, under the NIRA precedent, the Schechter precedent, would the Federal Reserve System be unconstitutional? And the answer is, of course, it would be. There's no difference. Why did it escape?
Why did it?
Because it wasn't part of the National Industrial Recovery Act. It was part of the Federal Reserve Act. The National Industrial Recovery Act only covered industries under that statute. And no one ever thought, apparently, to challenge the Federal Reserve System under the precedent of the Schechter case. And that's why we're where we are today, with this mess in which, who was this woman that's on the Board of Governors?
This is what I'm going to tell. This is my question to you. This is what I was asking. Okay, thank you for the context.
Okay.
Lisa Cook is the Fed governor.
Right.
Who was, I guess, identified as having perpetrated, or evidence is showing that she perpetrated some type of mortgage fraud. It's alleged, okay, but apparently there's evidence. I haven't seen it, but this is the kind of narrative that's going around. And Trump fired her, but she's still there. And she says she's not going anywhere, and he has no authority about it.
And I think some court ruled that she couldn't be fired.
Some court ruled she couldn't be fired.
The statute not only gives the president the authority to appoint people, it gives the president to remove them, quote, for cause, whatever cause may be. So I would think just at one extreme here, incompetence would be cause. You put someone on, he's been on for a couple of years, you discover he doesn't know what he's doing or she doesn't know what she's doing, you want to remove her. That would be cause, in my view. You don't know what you're doing. Now, if you're talking about involvement in crimes of moral turpitude, which is fraud.
Apparently there's 3 mortgages.
Whatever they are.
2021.
Okay, whatever they are. Typically, fraud is a bad charge to be hit with, right? And you can be removed from most government positions if you've been engaged in fraud, right? Because fraud would probably involve, to some extent, perjury. You had to sign something under oath to get a loan or whatever. It becomes complicated. And one would think that if that were proven against this woman, because I understand it's only alleged, right?
Well, apparently, the case has been referred to the DOJ, and
that's fine.
Evidence of it. There is paperwork.
Okay, but it hasn't been proven. There's a difference between being suspected, being under investigation.
So let me ask you a question, just a legal question right here, just for the audience and myself. So if the authorities have the paperwork where they can see that she has defrauded whoever she got the mortgages from, is that not evidence enough, or you have to go through the court system?
Well, it's not evidence enough unless she admitted it.
No, she's not admitting it.
No, she's denying it.
Right.
Well, then it's an allegation.
Yeah, she's basically saying that, I think my understanding is she's basically saying that was an accident or an oversight or something.
Well, that's fine. She's got a defense, all right?
Yeah.
But it's an allegation.
Yeah.
All right. So I would think the purest example of for cause is where they discover somehow that in the past she was actually found guilty in some way of a fraud, and she concealed this.
So, but for right now, my question to you
for right now,
does the president
No. I'm saying no because it's been alleged.
Yes.
But it hasn't been adjudicated.
You mean proven?
Proven.
Okay.
All right. Now, it might be that she knows perfectly well that her defense is no good. Right? And so she might want to avoid this by simply saying, well, I'm going to resign.
Apparently, she's suing to keep her job.
That's right. Okay, but I'm saying in some cases a person might say, well, in the back of my mind, I know I'm guilty, and I don't want to push this.
When she sues, who's paying for that? Is the U.S. government paying for that?
No, I would assume she is paying for it. I would hope that she is paying for it, right? But if she is defending her position in terms of the removal from the Board of Governors, then I would take it that she thinks she has a strong case for defending her position against any criminal charge that could be brought against her. That's what I would assume, right? And if I were her lawyer and we looked at the case in the back room, we said, yeah, it looks like you're guilty of fraud there. You did this, and the other thing. I think you shouldn't, I would advise, I don't think you should push this Board of Governors business. Just resign quietly, and we'll try to deal with this other thing later on. Let's not make a big deal out of the Board of Governors business, right? And draw a lot of attention to ourselves that we don't need. So if she's defending herself, I would say she probably thinks she has, and her attorneys probably think she has a sound defense. And at this point, the cause has not been established because it's simply an allegation. And what do we know? The first rule of the legal system, you are what? Presumed innocent until proven guilty.
Got it.
Right?
Yeah.
Okay. So in this particular case, she has to have the benefit of the doubt.
Yeah.
Now, if the Department of Justice comes back with charges and they indict her and it's going to go to trial, well, then someone in the Board of Governors might come to her and say, well, at a minimum, you have to, step down or don't become involved in our deliberations until you've been exonerated in the court case. But I think it would still not, because people are indicted all the time.
Right.
Who go to trial and it's a not guilty verdict. Right?
Yeah.
Okay? They're exonerated. So cause seems to me that it's actually been established that she's done something. Even in the case of, as I said, the earlier one, incompetence. What would you look at? Well, here's what she promoted. She promoted this. She promoted that. She did this and so forth. We can actually find things that she did that some competent person would say, well, this isn't the way the director should have voted on this. Or she's always in the minority. Or she's the radical. And she's the one person who constantly votes this way. And at some stage you say, well, this is a person who doesn't have the necessary competence to be on this board. And she's creating controversy and conflict and so forth.
Let's I get it.
You got it?
Yeah.
So there's a difference. We wouldn't have to find her guilty of something.
Yeah.
It's just her behavior as such. But when you start talking about committing criminal acts, those are allegations. They're not proof.
Understood. And I think that's a really good point, that there's a presumption of innocence until proven guilty.
And so I think there's an example where,
many of us have moved to the other side, which is accusing people before there's really
well, that's
evidence.
unfortunate.
It's really
But that's
sad.
an example of what I said before, of the president may have the power to do something, but is it prudent for him to exercise it at this point in time? Does he have enough facts to back up and justify the use of that power?
So can we go now to Jerome Powell?
Oh, Jerome Powell, yes.
The head of the Fed. And can the president, whether it's Donald Trump or anybody else, fire the chairman of the Federal Reserve?
Well, he's no different from any other member of the Board of Governors. He's subject to removal for cause.
So the cause could be, I think you're not lowering interest rates enough. You need to go. Is that
cause
cause?
could be, let me just use the big word. Cause could be incompetence. And one might make the argument, we have the Humphrey-Hawkins Act, which delineates from Congress's point of view what Congress should be doing, what the Federal Reserve should be doing. It should be maximizing employment, minimizing inflation, and I think the third was something, stability of the economy, whatever. There were three standards there, pretty broad standards. And those can be applicable to the Federal Reserve. The Federal Reserve is not independent of Congress. Congress has the power reserved in the Federal Reserve Act to amend, alter, or repeal any portion of the act at any time. So if you look at the Humphrey-Hawkins Act, you say, well, that's a directive to the Federal Reserve, which can be taken as an amendment or a supplement or whatever the Federal Reserve Act. And therefore, these people on the Board of Governors have to act in consonance with that statute. And now we find someone on the Board of Governors, maybe it's the chairman, who is not acting in consonance with that statute. He's not attempting to get all three of these things done at the same time. He's focusing on one to the detriment of the other two. And as a result of that, the economy is now skewed in the wrong direction. And we have huge deficits, or whatever the allegation may be. And at some point, one would look at this and say, that man's behavior demonstrates, I would say incompetence, but at least it demonstrates his unwillingness to comply with these statutory mandates of what the Board of Governors should be doing, Federal Reserve should be doing. And I, as president, think that this is cause. An incompetent person should not be on this very important board.
So let's say he fires Jerome Powell.
He fires him, and now Jerome Powell can do what this woman is doing.
Right.
And he can go into court and say, this is not cause.
Can he still run the Federal Reserve?
Well, I would think it would be appropriate for him to remove himself from any decision, certainly where he is the deciding vote. Mm-hmm. Okay. So
well, apparently Lisa Cook is still on the board and is making a decision I'm just saying to you, I'm just letting you and the public know, and will be sitting on the Federal Reserve meeting and having a vote on whether the American people will see lower rates or not.
Well, that's fine.
Because again, she's presumed innocent. But what I'm saying is, in the case of Jerome Powell,
well, in the case of both of them,
yeah,
to make it absolutely clear that I'm not doing anything that could be labeled as cause, I will sit with the board and I'll listen to the arguments and so forth and discussions, but I will abstain from voting. I'm going to remain on the board because I think I'm entitled to be here.
Do you really see that happening?
But I'm just saying that's what I would do. I would abstain from voting because there's this cloud over my head and I'm in litigation against the president over the for cause element, right? And I don't want to taint in any way the decisions of the Board of Governors by my vote.
Okay.
That would be the prudent thing to do. I don't know what she's doing or Jerome Powell is doing, but if I were their lawyer, I'd say, this is what I would recommend. As long as we're having this problem in the court system and you're under this cloud, as ridiculous it may be, right, whatever, then you should abstain from the actual vote. I wouldn't abstain from discussion.
Does the president
from the vote.
Have the authority to appoint a new Fed chair if, in fact, he fires Jerome Powell and Jerome Powell decides not to leave but to sue him?
No, because the term of the Fed chair is the term of the Fed chair, and he would have to be removed to put somebody else in. Retirement, death, or removal by cause.
Okay.
And that's what he's claiming, I take it. He said, I can't be removed here because the for cause element has not been met. And I'm not dead, and I'm not retiring. You can't just simply move me out of this position because the position of the chairman is a separate position within the Board of Governors structure.
Yeah, I hear what you're saying.
Yeah, no, and it seems like a hard-nosed position to take, but I think it's a fair position to take.
You and I did a piece called "Can the Government Force You to Buy Anything?" back in 2012. We did another one in 2014 called "America: Its Founding Documents and Status." We did one last year in November called "Unpacking Tyranny with the U.S. Constitution." Hold on here. I want to share with the audience. And we did "Calling in the Constitution" back in 2020. And we are doing the work of today. And I'd like to have you back to talk about Crashmaker with us. And if you could talk like a minute or two about Crashmaker and why it's important.
Oh, that was a novel that I wrote in conjunction with a friend of mine, Victor Sperandio, who is a legendary securities trader on Wall Street, now lives in Texas, I guess, and primarily in retirement. And the theory of this book was, what if someone could manipulate the markets in such a way to cause a financial calamity, undermining the Federal Reserve, and then somehow arrange through the use of prudent campaign contributions to elect a majority of people to Congress that would then deal with removal of the Federal Reserve, bring us back in the sound monetary system. What might the intrigues look like? And so it's a bunch of characters that take on this aspect of some people and other people, historical figures, whatever, and how this would be manipulated. And in fact, the book gives a description of exactly how you would manipulate the market to create this crash, right? Because you'd feel.
Are we talking about naked shorting, like Patrick Byrne
all
about?
sorts of things like that. It's described, okay? And then the consequence of it would be this political upheaval that takes place. And it involves more than simply the Federal Reserve, because the people who are elected to Congress have, I guess it would be called today, a MAGA approach to things. America first, we're going to bring back constitutional limits in various ways. And they do. And this completely disrupts the other side, because now they're confronted with a whole series of separate constitutional fronts and legislative fronts. And how do I deal with this? Well, I'm dealing with that. And how can I solve this problem? Well, I'm trying to solve this. It becomes very complicated. And it opens up whole vistas. How you could essentially put, what is the expression? You throw a hand grenade into Congress, and all sorts of things blow up. But the idea was to expose the Federal Reserve problem and how its manipulation of the markets, money, credit, and so forth and so on, was driving the country to destruction. And hasn't it? Yeah.
I interviewed the G. Edward Griffin, who wrote The Creature from Jekyll Island
right.
years ago.
Right.
And he's still with us.
Yeah, well, he's got a very good history of the secret genesis. It's not actually secret. They met on Jekyll Island, which was a private hunting club in Virginia.
Isn't it in Georgia?
Yeah, excuse me, in Georgia. And this was the 12 conspirators. And they met in this one room in the club, which is still there. It's a very old building. The building is still there. I think Marriott built a high-rise hotel. So you can go there. I've been there a couple of times. And they will show you the Federal Reserve Room. It's called the Federal Reserve Room. This is where they met, and they have pictures of every one of them except for one. I guess the family must have objected to putting the picture of this one guy there. But they have the others there. And here's the table where they sat, and they discussed how the Federal Reserve Act was going to be drafted and so forth and so on. Senator Aldrich, who was the main man in the Senate, and these other people had banking connections. And then they put this thing through. Thank God for Woodrow Wilson. He gave us the Federal Reserve. He gave us World War I, right? Probably one of the worst presidents in American history. And they got it through in December of 1913, just around Christmas time.
Do you think that they are responsible? Sorry to interrupt you here. Do you think that the Federal Reserve is accountable on a huge level for the mismanagement and the destruction of the economy?
It couldn't have been done without. It couldn't have happened without the Federal Reserve. Let's put it that way. What does the Federal Reserve do? It's there to monetize government debt. It's there to support government borrowing. And this goes back to Alexander Hamilton. Hamilton's theory was, and he expressed this, he said, the government needs to support the financial people in New York and Philadelphia at the time, but now it's New York, because those are the people who will support the government through loans. The government may not be able to raise enough taxes under certain circumstances. It will need to borrow. To whom are we going to go for the money? That's those people. And therefore, we have to give them some kind of favoritism in our system. He was very much in favor of a central bank. He was very much in favor of what we would call deficit finance. Right? He was the man that pushed the whiskey tax. Remember, they had the Whiskey Rebellion. The first Secretary of the Treasury, and the first thing he puts through, one of the first things he puts through is the whiskey tax, and he has a rebellion on the frontier in Pennsylvania because of this. He eventually is killed by Aaron Burr at a duel. God, no. Aaron Burr then becomes a revolutionary, the famous Burr case. I mean, if you look back at the history, it's fascinating. But in any event, he tried the first bank in to get a bank in the United States. There was one put in, that went out of existence. There was another one put in. There was a famous bank fight with Jackson. That went out of existence. For a long time, we had no central bank, so-called. We had national banks, And they were limited because the amount of currency that they could produce was 90% of the amount of government bonds that they held. So they had to buy government bonds in order to issue currency. And after the Civil War, people were not terribly interested in increasing the debt of the government. They had enough debt coming from the Civil War. So there's a limitation there. And the Federal Reserve came along to be the lender of last resort, to kind of open up the floodgates to this.
Did.
And it did. Just in time for World War I, interestingly enough, our involvement in World War I. And then, of course, in the Depression, World War II, and subsequently, it's been nothing but. And the interesting thing is what it destroyed was we had the largest gold stock in the world after World War II, because we started off with a large gold stock, and then a huge amount of gold came in to pay for armaments, and a huge amount of gold came in for security. So by 1953, we had the largest gold stock in the world. From 1953 to 1971, when Nixon finally decided that the outflow of gold to foreign governments was too great, over 50% of the gold disappeared. It went into foreign transactions.
Do you think the gold is at Fort Knox? Anything is there?
Which gold?
Well, we know Germany's gold, the U.S. said years ago, is gone.
Well, there's good delivery gold, which is 0.999% pure. And then there's coin melt gold, which is less pure. Because when the coinage was called in by Roosevelt, he made sure that coinage was not going out again. He had it all melted down into what they call the coin melt bars.
Oh, really?
Okay. So if you were to do an inventory, you might get a number of bars, but you would have to do an accounting to find out actually how much gold was there, because some of the bars are 0.999, good delivery, and some of them are much less. So we don't know the exact relationship.
We never got the answer to any of that, remember?
No,
Months
they
ago?
held a couple of dog and pony shows.
Right.
Where they took some members of Congress down, and they let them look in the window of one of the vaults. See, look at all the bars in there. What they didn't have was an accounting of an assay of all the bars. Okay, so we don't know. We know a huge amount of it went out. We know some of it's at West Point because they moved some of it. There's an interesting picture of the 18-wheelers coming out of Fort Knox, which were going to West Point. And some of it's still in Fort Knox, and we don't know. And we know that when Germany asked for its gold from the Federal Reserve, it took how many years? The Federal Reserve stalled.
I think it was like 8 years.
Yeah, it's a long time. Now they could have brought a what are those called?
I think their first answer was, we don't have it.
Yeah, well then the question is who stole it.
Well,
that's right.
That's what I remember. Okay, this is years ago. They said we don't have it.
Yeah.
And they made Germany wait. I think it was 7 or 8 years.
Yeah, and the Germans sure said, well, why don't you just open up your account books and see where it went?
I want to invite you back to discuss the monetary system as a completely separate piece when you're ready. Dr. Edwin Vieira, thank you so much for being here. I can't thank you enough. You really are the embodiment of the history of the United States. When you speak, I feel like I'm initiated into that time and that situation and the conditions in which you speak. You have a way of bringing us right there.
It's a frightening story, isn't it?
Kind of. Also fascinating, too.
Well, fascinating and frightening.
Yes. I want to say thank you, and I want to have you back. And I really, really appreciate
thank you,
who
sir.
you are and your legacy
pleasure.
and the years that you've spent caring about the United States and the world, but really, really doing everything you could to have people understand the U.S. Constitution, the Bill of Rights, and the Declaration of Independence. And I think we're either going to return to it, or I'm afraid it will be lost.
I think you're right on that score.
It's up to us.
Yeah, absolutely.
If you would like to reach Dr. Edwin Vieira, you can go to newswithviews.com. So, ladies and gentlemen, this is Kim Greenhouse from It's Rainmaking Time. You can also see other interviews with Dr. Vieira at Drawing the Line in the Sand in Texas with the U.S. Constitution. That was done in January of 2024. We did one in June on presidential authority in the U.S. Constitution, but a different take than we did today, and calling in the Constitution in 2020, and which was heavily suppressed all over the internet. And we ask you to share this show. We ask you to come to itsrainmakingtime.ch. Unfortunately, we've had to deal with heavy censorship on the other platforms. I'm heavily on X because that's where I get to share my work the most for the show and also my business, the Rainmaking Company. And we thank you so much for being here. It's Rainmaking Time. Thank you so much.